And well, if you're not familiar with the program, we do multi-stream across a number of different platforms, and YouTube always takes a quick second to get started. And so we just need to wait for it to get fired up. And it looks like we're almost there and we're live. So let's get moving. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow. But sometimes they have a little bit of difficulty doing so themselves. And that's why we started this program called Watching the Watchers, so that together we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. And that's why we're so grateful that you are here and with us today. It's been a little bit of a long weekend. We've got some stuff that we want to get into, particularly about, some of the political stuff, some stuff to clean up from last week. And we're going to be talking about the impeachment. We're sort of getting ready for next week. I believe is going to be the real week that we are hearing more and more information about what's going on in terms of how the impeachment trial will be proceeding. But today we learned that Chief Justice Roberts may not be a part of it. And so we want to break down what that means and what the news is surrounding that. We're going to talk a little bit more about Rudy Giuliani. You probably have learned that he is also being sued by Dominion. We talked about Sidney Powell, who was being sued by Dominion. Very similar type of lawsuit. They're asking for another over $1 billion. I think they want $1 billion, 1.3 from Sidney. I think they want another 1.3 from Rudy. So they're really going to be doing pretty well if they're successful in these lawsuits. But want to break down what that looks like. Kind of an interesting lawsuit because Rudy Giuliani is an interesting character. We're going to be getting into that. We're talking about a new Arizona bill. In Arizona, they are going to be introducing a bill. There's a guy here by the name of Walt Blackman, who is submitting a new House proposal that will criminalize abortion. In other words, if you get an abortion or you perform an abortion, they're going to be asking that you are charged with murder. Kind of a controversial little bill there. So we're going to break that down. But before we do, let's talk about some case updates. We've got Kyle Rittenhouse in the news, who had his release conditions modified a little bit over the weekend. We've also got Daniel Cameron. You may remember him. He was the attorney general in the Breonna Taylor case. And we've talked a lot about both of those cases historically. And now's a good time to check in a little bit of updates on both of those. So we're going to start with them. Before we dive into the material, a couple quick reminders. If you're not already a subscriber of the channel, we'd appreciate a subscription from you. I would appreciate a thumbs up, a comment, a share of this video amongst family and friends. Invite them to come join us. We go live at this time of the day every single day of the week, except the weekends, only on the weekdays. Got to get a little break in there. So we'd love it if you joined us on that. We would also, another quick reminder, we transitioned over to locals.com. So watchingthewatchers.locals.com is our new non-YouTube home base. That's where we're going to post a copy of the slides at the end of the broadcast. So the way that this works is I'm going to go through some primary source documents. We're going to look at the news. We're going to look at the actual documents from the courts or from the prosecutors or from whomever. And if you want a copy of everything I'm about to go through, you can catch that over on locals.com. watchingthewatchers.locals.com. Can also get a copy of the book, my book, for free over there, amongst other things. The existence systems, the impeachment party documents, which are going to be relevant pretty soon here, even today. And so we want to invite you over there. We're also going to be getting to Superchats and the live chat at the end of the broadcast. So feel free to send those in as we're going through the show. Miss Faith is clipping those, and I'll address them near the end of the broadcast. All right, so let's get started. I want to start with Kyle Rittenhouse. We spent a lot of time studying Kyle's case, did some very detailed analysis. If you don't recall who Kyle Rittenhouse is, you will, how can you not? If you've been a regular of this channel, we've been talking about him for months. Quick refresher. This was the young kid, the guy who was 17, I think he's 18 now, who was charged with a number of different counts, 6 counts it looks like. And this all sort of originated out of a series of protests that took place back last year when Kyle Rittenhouse was out there as sort of part of a group of individuals who were protecting property against rioters and looters who were just combing their way through Kenosha. You sort of, in the context of the aftermath of the George Floyd riots, Ahmaud Arbery riots, Breonna Taylor, and so some of that unrest that was going on in the summer that we all recall. Kyle Rittenhouse was out there, and he was sort of in this altercation where he had a weapon, and he shot and killed 2 individuals, injured another one, and it was charged with basically murder out of Kenosha. And for a number of months, he was sitting over in Illinois. He was sort of partially being represented by Lynn Wood, if you can believe it, and another guy by the name of John Pierce, and some others. I've had a lot of criticisms about his defense team thus far, but when we analyze the underlying facts of Kyle's case, in my mind, this was a pretty clear, cut and dry case of self-defense. I'm a criminal defense attorney. We went through the statutes, so I wasn't applying Arizona law. We were looking at Wisconsin law. We were looking at the facts. We had a map. We sort of were reassembling a lot of the imagery, and we were doing audio timelines and looking at the gun spikes and the sound, the audio crackles in the gunshots. It was a lot. Well, it's been very, very quiet for a long time as it relates to Kyle's case because he's been sitting in Illinois. His attorneys were trying to, argue against extradition, all a bunch of nonsense. Anyways, that is done and over. He was transported back over to Kenosha, Wisconsin, and then he was released from custody. And you remember, he was in custody for a number of months. One of my arguments was, well, send him right back to Kenosha so that he could post bond and then get out of custody. For some reason, his lawyers just didn't do that, but he's now back in Kenosha. He was released on bond. It was a $2 million bond. And then very recently, some interesting photos of him popped up in the news. And over this weekend, some of those release conditions were sort of clamped down just a little bit. So what am I talking about? These are the photos that were pulled over from Hot Air, and I think hotair.com got their article from the AP. But this was the photograph in controversy right here. And so you can see this is Kyle Rittenhouse along with 2 other individuals. I'm not sure who else was there at the time, but Kyle was there. He's got a shirt that says free as F, and the F is sort of blanked out there. So obviously it's the F word, so free as F. And then many people are sort of up in arms about the OK symbol that he is posting up right here. So OK, or as some people are saying, that means white power somehow, because I think the 3 fingers there look like a W, and then the thumb and the index finger are circled to form a P. So apparently that means white power. I don't know how much truth that is or not, but you can leave that up to your interpretation. Looks like this guy behind him is also doing the WP on the back, so the OK symbol. And then you've got, it looks like down here, he may be trying to do something similar with his other right hand. So not Kyle, but the other person in the photo. And another individual is taking a photograph of them. And so, this is, I would say, not a good image, just right off the top. If you're a criminal defense attorney and your client is out there who's 18 years old, who's out at bars, and he's being charged with 6 counts, 7 counts. A number of those are murder charges. Not a good look, right? If this was my client, I would be very unhappy with him about this. In particular, going to a bar, in particular, sort of wearing a shirt that is overly provocative, free as F. It's like, hey, man, you're out of custody because of some level of, graciousness from the system. And we got to play ball with the system. And I know some defense attorneys don't view it that way, but I do. I view it as, this is something where you want to sort of fly under the radar, be on your best behavior as the case is pending. And when you just are sort of floating around with a shirt that says free as F, and you're throwing up, questionable hand signals, whether you can argue about those or not, it's just not a good look. Now, to Kyle's defense, my understanding is out of Wisconsin, there is a law that allows, I think he was there with his mom. There are laws that allow you to be with your mom or with an adult and a guardian, I think. And as long as you are with them, you're okay. I think you can even consume alcohol. So, he's probably within the confines of the law here. It's not what I'm arguing. I'm just saying this does not look particularly good. Remember, we're talking about 2 different things. We're talking about the court of law, in which, right, he's on release conditions. If the judge didn't say he couldn't go to a bar originally, then he's not in violation of any law or any court order, presuming that the underlying release conditions were satisfactory. he wasn't doing anything wrong. He's still innocent until proven guilty. This is America, and he's allowed to go out there and do certain things. But that's only in the court of law, and we're going to see here that the judge modified that, pretty considerably, I would say, and the judge is allowed to do that. Now, on the other side of the analysis, we're talking about the court of public opinion. Okay, he is somebody who's a high-profile case. He's going to be in the minds of jurors. There are going to be a lot of people who know about him and know about the case. The judge is going to ask them, can you be fair and impartial? Is this something where you can sit on the jury and just analyze the facts, and all of the media noise, all of this other stuff, you can just sort of defer that out of your mind, right? And jurors are going to say, yeah, of course I can. Sure, I know I can. But they can't really, right? They can all say that, but we all know how this works in our minds. Many people who are jurors, their minds are sort of made up before they even see the defendant or hear any evidence. Sometimes some studies will show as soon as they see the defendant, as soon as the person walks through the doors, jurors just go, oh, that guy's guilty. That guy's innocent. That guy, oh, maybe I'll listen to him. Maybe I'll stay undecided. But a lot of people just sort of make up their minds. And so in a situation with Kyle where he's so high profile, people on both sides of the aisle are just up in arms in both situations. Some people say, he's a murderer and he shouldn't have been out there and he was killing innocent people. This wasn't a self-defense case. And the other side are saying, yeah, it's a right to keep and bear arms. It's a right to defend property. He was acting out of self-defense. This whole prosecution is a sham, and he should be, released and receive a letter of apology from the Kenosha district attorney. And it's usually somewhere in the middle where the truth lies. And so if Kyle is in front of a jury and they see him, if they see these photos, which, by the way, are probably going to get exhibited at some point or submitted into evidence or made a part of the record, you can see right here the government's photo. They've already marked it down here at the bottom right. It says States Exhibit J. Okay, so they are marking this as an exhibit, and it's going to be very curious if this changes the strategy of the underlying defense. Are they now going to be saying that we hadn't heard any of this thus far, that Kyle Rittenhouse was somehow associated with the Proud Boys or with, one of these other, quote, white supremacist groups out there? That word is being thrown around a lot right now. It's sort of hard to keep track of who's a white supremacist and who isn't these days. But, I don't know if they're going to try to connect him back to one of these other groups, or if the underlying facts that surround the night in Kenosha, if they show that there were those groups that were there and prevalent. We just don't know because it wasn't in the record. Remember, we read the probable cause statement, and the probable cause statement didn't mention anything about that. It was just sort of talking about the facts of the case. Now we have this whole potentially racial component that's introduced into it. And as a defense attorney, that is not something that I think bodes well. So once again, let's take a look at the article. This comes over from Kenosha. It happened in Kenosha. This was written by Jazz Shaw over at hotair.com, and he's referencing the Associated Press. Says Kyle Rittenhouse isn't scheduled to go to trial until March 29th, though his attorney already is requesting more time to prepare. That's not unusual. I'm surprised at this. I really don't think that this case is going to go to trial on March 29th. Murder cases, murder trials can take a long time, months and months and months, sometimes years, in order to get resolved. So that doesn't surprise me at all. He's facing 6 counts associated with the deaths of 2 people and a shooting of a third in Kenosha. He found himself back in front of a judge this week and with additional restrictions. What sort of restrictions? At the request of prosecutors, he's now barred from knowingly talking to or socializing with white supremacists. And we're going to look at the order from the judge here in a second. The strange nature deserves a closer look, but it's apparently resulted from a complaint made by someone who saw Rittenhouse out at a bar with his mother. In addition to not being allowed to talk or consort with people who might be described as white supremacists, the judge further ordered Rittenhouse to not consume or possess firearms. And Jazz was noting, something tells me that Kyle needs a better attorney. So let's take a look at what is going on in this case. Remember, we haven't spoken about it in some time, so I wanted to back up a little bit. Back last year on December 22nd, that was the arraignment. And there was some news. Some people were asking me, what happened at the arraignment? An arraignment is very, very formulaic. It's very procedural. Nothing typically interesting happens. We already knew what his bond was. We already knew that he was out of custody. So an arraignment is very inconsequential in most situations. The judge tells you what you've been charged with, confirms your release conditions, and then sets the next court dates. It's pretty basic, and that's exactly what happened here. His attorney is Mark Richard. Filed some sort of a motion requesting a 6-person jury trial. Additional text happened on the arraignment. It says Attorney Thomas Binger for the state, and we saw him during one of the virtual hearings, he said the defendant appeared in court in person with attorney Mark Richards, the clerk JT, minutes all by Zoom. Information previously filed acknowledged the reading was waived, so they didn't read him and go through his entire indictment. Entered a not guilty plea. Pretrial conference was scheduled for March 10th. Jury selection March 29th. Cash bond continued. So if you recall, Kyle Rittenhouse posted the bond of $2 million. He sat in custody in Illinois for a long period of time. Well, I don't know, they were raising money or something like that, but he finally got out. And then let's take a look at what happened next. So on January 11th, we had some jury fees, some additional text, and then something interesting happened on the 13th of January. So just about 2 weeks ago. We see here that that must be the Associate District Attorney, Thomas Binger, and his exhibit attachments were all submitted. We have a motion to modify his bond conditions also on the same day. And then they provided a white envelope marked with exhibits E through F containing a flash drive in support of the state's bond dropped off to the court. The judge has the envelope containing the flash drive. And so this is presumably the motion to modify his bond conditions or his release conditions. And I don't have a copy of this document, but I'd be very curious to see what Binger was actually asking for. You know, what was he requesting? Was he saying, was he asking to revoke the bond? Was he saying take him back into custody? Or was he suggesting some of the restrictions that the judge ultimately put in place? But you can just see here sort of the trifecta. We've got an exhibit, an affidavit, presumably from somebody who was in the bar. We've got a motion to modify the bond conditions from the district attorney. And then we have a number of the exhibits that were also submitted on the 13th. Then we come back, and a couple days later, there is a hearing. And this is what the judge ordered. So we're sort of referencing back to this $2 million bond. And here's what the judge said. The defendant shall return the signed bond to the clerk within 10 days. Okay, that was done. Looks like that was done on the 22nd. It was signed and amended immediately thereafter. And the court says the defendant, or the dedant here, says, shall neither possess nor consume alcoholic beverages, which is a very standard release condition. That happens in a lot of criminal cases, regardless of anything. You could be charged with a disorderly conduct case just for getting into an argument with some guy cutting your grass, right? Nobody's drinking, but the judge may just say, okay, no more alcohol while things are a little bit stressful. It goes on, the defendant shall not knowingly have contact with any person or group of persons known to harm, threaten, harass, or menace others on the basis of their race, beliefs, on the subject of religion, color, national origin, or gender, no weapons, especially firearms, no contact, including the residence, electronic, or third party with any of these other people. So Richard M., Gage G., Dominic B., Charles R., Karen B., and John H. Some of those people, I think Richard or Gage was somebody who got shot. And the others, I just don't know who they are off the top of my head, but take a look here. You know, this is sort of, I think it's we know what the judge was asking for, but they didn't actually say white supremacists in there. You know, they didn't say you can't talk to white supremacists, but you can go talk to, some other ethnicity supremacist or some other group's supremacist. It just sort of said anybody who's related to an organization that threatens, harasses, menaces anybody on the basis of their race, beliefs, religion, color, origin, or gender. So even broader term than just white supremacist. I think that the white supremacist thing was not actually stated in the judge's order. And this is right from the docket. I don't see that anywhere other than it's just don't communicate with anybody who's involved in that type of organization. Of course, that was emailed over to the attorney. The office received it. It was signed and amended shortly thereafter. So, I don't have any particular issue with that. I'm very glad they didn't take him back into custody. If I was his attorney, I would have certainly been telling him to not associate with any of those people. At this point in time, Kyle, if he were one of our clients, let's say, he's a high-profile case, national news media, national attention, he shouldn't be going to bars, wearing T-shirts like that, drinking any alcohol, right? He's an 18-year-old kid. And my thought would be, he's a man, right? He's not a kid anymore. He's a man, and the thought here is only good stuff, only positive stuff. The only images we should see of him on the media are him volunteering at a food bank or, helping a little old lady across the street or, rescuing puppies who were, shoved in a gutter somewhere, right? That's the type of media that you want. You do not want free as F on your T-shirt when your case is still pending. They don't teach you this stuff in law school, folks. That one's free. Okay, don't wear those types of clothes if you are going to be in the middle of your criminal case. Not good. Here is Kyle Rittenhouse. This is what's happening for him next. So he is scheduled for a couple different court dates. I am blocking the image, but you can see on March 10th at 9 a.m., final pretrial conference is being scheduled. And then on March 29th, we have a jury selection that is scheduled in front of Bruce Schroeder over in courtroom 209 there. And the likelihood that I think that this actually goes forward is probably slim to none. I'm going to guess that they're not ready in a couple months, like 2 months from now, to do a full-blown jury trial. I would expect several continuances here, but we're going to see. So that was Kyle Rittenhouse. All right, the other one that we've been following a lot is Breonna Taylor. This one is pretty interesting. Breonna Taylor, of course, if you don't remember Breonna Taylor's case, Breonna Taylor was the woman who was shot and killed when we had 3 officers sort of just kind of a break into her apartment and just start firing off rounds throughout the building. And it was problematic. We went through a lot of her case in depth. We were sort of analyzing the 3 officers who were involved. One officer went back and talked with another officer when he was in the hospital. There was a lot of bullets that were sprayed out throughout their residence and throughout the neighbor's residence. And then the big question was, well, was there any malfeasance? Did these cops screw up? They were at the wrong residence. Breonna Taylor was killed. Some people were saying she was sleeping. Some people saying she was up. And all of that I think is pertinent, but it's not particularly dispositive. I think the police were wrong either way, whether she was asleep in her bed or whether she was standing up there going, what the heck is going on? She's dead. The police shouldn't have been there. And they screwed up. So the next question was, well, is there going to be any recourse? Are these cops going to be charged with anything? And they were sort of, but it had nothing to do with Breonna Taylor's case. And now some of the grand jury people who heard the evidence that was presented by Daniel Cameron, who was the attorney general at the time, or currently is the attorney general, the way that this works is the whole ordeal with Breonna Taylor happened. Okay, now the cops are suspected of some criminality or some malfeasance, let's say, and they were now being investigated. And the way that works is the government would present evidence to a grand jury. A grand jury is a closed-door proceeding. It's a private proceeding. The defense is typically not allowed to come in and make arguments. There are certain rules that allow them to have some say if they invoke those, but that just wasn't the case as far as my understanding is here in Breonna's case. So Daniel Cameron was presenting evidence. So Daniel Cameron is a law enforcement sort of extension. He's the attorney general, the chief law enforcement officer of the state. He was sort of governing how this entire grand jury indictment proceeding was taking place. So he was I would say, dictating how certain evidence was presented in front of the grand jury. And the grand jurors then would decide whether there was enough there to charge these officers with a crime for what they did to Breonna Taylor and her boyfriend, Kenneth Walker. And the grand jurors, they heard everything that the government presented to them. So in this case, the government is sort of presenting evidence about themselves, right? Because the police work for the government. And the evidence that they presented was not persuasive enough to the grand jurors to convince them to convict or to charge the officers with any crimes. Well, after the grand jury indictment and the proceedings were over, now the grand jurors are sort of looking at the rest of the evidence that they didn't get in that secret closed-door proceeding that was the grand jury indictment proceeding. And now they're going, think we might have been misled a little bit. Maybe there was some other evidence that they never told us because they didn't get access to it, right? We as the public were sort of just combing through all of this evidence and saying, this is pretty bad. And they just never heard any of it. So now that it's over, they're not happy, right? Because they were a part of a proceeding that sort of let some pretty bad actors just go free. Now, what are they doing? They are filing an impeachment petition against Daniel Cameron, the Kentucky Attorney General. So folks, they just joined the impeachment party, if you haven't noticed that. Let's take a look at this article from The Hill. It says 3 grand jurors from the investigation into the police raid that killed Breonna are now calling for Attorney General Daniel Cameron to be impeached over the allegations that he mishandled the case. Jurors on Friday filed their petition with the state House of Representatives, arguing that Cameron breached the public trust and misrepresented key grand jury findings, according to the Louisville Journal, or Courier Journal. According to Louisville, it says here, Attorney General they're claiming in the petition that Attorney General Cameron deceived the American people and the citizens of the Commonwealth. The petition reportedly claims that he improperly used public funds, and his office did not immediately respond. They say in a press conference, he claimed that there were 6 possible homicide charges brought before the grand jury in their investigation, but the multiple grand jurors have claimed they weren't given the opportunity to deliberate on additional charges outside of the counts of wanton endangerment. And remember this, they actually were, I think, were they charged with wanton endangerment? I don't recall. It doesn't matter. I mean, it sort of matters, but it's not what people were looking for. There was a conversation about whether them just firing ammunition, just mowing through the walls, and the bullets went through Breonna Taylor in her apartment into another neighbor's apartment. And so any charges that came out were all related to sort of endangering people in the other apartment buildings, not Kenneth Walker, not the death of Breonna Taylor. And so people were up in arms about that. Now, let's take a look at the affidavit. So this is the article-ish of impeachment that we've already gone through one of these, several of these now. And this is the newest addition to the impeachment party. They're getting in on it just like the rest of the country, apparently. So here it is, Commonwealth of Kentucky, Kentucky General Assembly, verified affidavit and petition for impeachment. Come now, the undersigned petitioners and affiants, having duly been sworn, they're saying that Daniel Cameron engaged in, quote, misdemeanors in office as defined in the Constitution and as outlined in this document, which, this is great, which shall be considered an affidavit by the parties, including the following. So they're saying this is what he did. He engaged in the following. And the first one, folks, if you can't see it, incitement of insurrection. Huh? So you can just get incitement of insurrection for basically anything in this country now. It's the first item on this article of impeachment. We talked about this a lot last week when we had or a couple weeks ago when we had our impeachment party, when Donald Trump was impeached on the 13th. We said incitement of insurrection. Man, that standard is so low that you can just impeach anybody for that, as long as you have something they said and something bad happened later down the line. Boom, if you can make an argument connecting A and B, it's game over. Every single person in this country can be impeached for incitement of insurrection. And it's the first one. It's the first one on their article. Incitement of insurrection. They also are pointing out here a breach of public trust, failure to comply with duties imposed on him as the chief law enforcement official, abuse of the office and state property, and other misfeasance and malfeasance as outlined herein. So let's run through some of this. It's a big, long document. I'm not going to read the whole thing. I just want to show you a little bit about what it looks like. We may spend a little time on this incitement portion because it's just beautiful. It's all coming together, folks. Here it is. It says, number 1, relevant facts in support of impeachment, impeding a criminal investigation and false statements about a criminal investigation. So they're saying here they're going to impeach him under Section 68 of the Kentucky Constitution. They define what the law is a little bit. So it's KRS S55. Okay. And it says here, after the Kentucky Commonwealth Attorney Jefferson recused himself as prosecutor, Cameron, as the Attorney General, assumed the role and moved forward with the investigation of Breonna Taylor and the officers who shot Breonna Taylor in her home. Cameron presented his investigation to a grand jury on September 21st and 23rd. On the Wednesday of September 23rd, Cameron gave a press conference, and we covered that here, I think. It says, at the press conference, Cameron said his office presented, quote, all of the information and walked the grand jury, quote, through every homicide offense before the grand jury came to its conclusion. And that's not really true. According to the 3 grand jurors, neither Cameron nor anyone from his office mentioned any homicide offense to the grand jury. Not only were no homicide offenses presented as alleged, no charges of any kind were presented to the grand jury other than the 3 wanton endangerment charges against Detective Hankinson. And Detective Hankinson, if you don't recall, I think he was the one who was outside. You had Mattingly, who was first through the door. Hankinson was sort of outside, heard the gunshots, and then just started popping off right into sort of from the exterior of the building, just started firing through the walls. And so they were charging him with wanton endangerment. You can't just start blindly firing into a residential building. That's insane. So they charged him with that. And this was echoed by 2 other grand jurors' complaints that the panel wasn't allowed to consider additional charges because prosecutors told them the use of force was justified. So the whole thing was a sham. With regard to the murder of Breonna Taylor, a citizen and resident of Louisville, Attorney General David Cameron misled the public and misrepresented the actions in the citizens. So yeah, I remember this. We did play a little bit of Daniel Cameron saying a lot, right? He was being very, very careful with his words. And apparently the allegation here was, I remember one of the quotes that he gave was, well, they didn't ask about homicide. They didn't ask. they're a grand jury. They're an independent body. They can investigate whatever they want. I think was his response. Well, you know, somebody in the news was asking him about that. Hey, did you present any of those homicide charges? Like, you know, the thing that everybody's kind of upset about. Did you like talk about that at all? Well, they're an independent body. You know, the grand jury is capable of asking pertinent questions, and they didn't ask any pertinent questions. Therefore, you know, we left it up to them to decide. All right. So you're telling me that you're the attorney general, you are the government, you're in charge of properly investigating yourselves, and you didn't do that. Is that what you're saying? Well, it sounds like it. Attorney General Cameron deceived the American people, according to this document. Attorney General misled the public and said, and the investigation found, and the grand jury agreed that the police were justified. He said here, were justified in the return of deadly fire after having been fired upon. When asked if the grand jury considered manslaughter, reckless homicide, or other charges, Cameron said, our team walked them through every homicide offense. And then the grand jury was ultimately the one that made the decision about indicting. In fact, those statements were blatantly false and have been refuted in legal actions and arguments before courts in this Commonwealth. They say he made statements about the grand jury. They were based on what certain witnesses said, further laid those decisions at the feet of the grand jury while failing to answer specific questions about the charges. False claims. The jury diminished the liability. Okay. So you can see it just keeps going on and on. They're looking at more rules. You know, what can a lawyer do? A lawyer shall not knowingly make a false statement of material fact to a third party. Right here, Attorney General Cameron's press conference regarding that, he knowingly and intentionally made numerous material false statements with regard to the evidence. Supreme Court has a lot of ability to govern this stuff. Here's another misdemeanor that they're claiming he did. They say he's a public servant and a civil official. He lied to the public about what he told the grand jury, violating the duty he owes. And then this is where we're talking about the insurrection, okay? Insurrection, incitement and support of insurrection and violence. And, you know, this is interesting because I thought that Donald Trump was responsible for the incitement of the insurrection, according to the Democrats. You know, they said that his speech there at the Save America rally was a little bit troubling because he said something to the effect of, if you don't fight for your country, you're not going to fight. You're not going to have a country anymore, right? If you don't fight like hell, you're not going to have a country anymore. And he said something else, and then there was a settlement conference with Brad Raffensperger they were very upset about. So in their impeachment document, that was the standard, very, very low standard. Essentially, if you gave a speech, then that's enough. And we were wondering, well, how did Daniel Cameron, how was he involved in the insurrection? Because if it was Donald Trump's language that did it, then how could anybody else be responsible for the insurrection? And if Donald Trump's speech didn't do it, then who is responsible for the insurrection? So if Donald Trump didn't do it, did Daniel Cameron do it? Well, let's take a look. It says here, the support for the unlawful actions on January 6th. And so that was the day of the Capitol Hill riots. Attorney General Cameron permitted and supported RAGA, which doesn't sound like MAGA, but sounds pretty close, the National Association of Republicans Attorneys General, to recruit, aid, and abet persons who went to the Capitol to engage in felonious acts of destructions and violence. So this resulted in millions of dollars of damage. AG Cameron is a member of the RAGA Executive Committee, which made decisions about the use of the organization, resources, and political capital, exacerbating the deep political divides and damage that occurred on January 6th and encouraging illegal and damaging behaviors. So very, very, very loose connection there. If you are a part of the Republican attorneys general and you raise some money and some of that money goes to something else that exacerbates the deep political divides, there it is, exacerbates the deep political divides and damage that occurred on the 6th, well, that's it. I guess that's it. That's how it works. That's insurrection. And he incited insurrection. RAGA paid for radical robocalls, inciting citizens to attend the violent actions in D.C. Attorney General Cameron is a member of RAGA, and he's involved with its action group. So as a member of RAGA's 9-person executive committee, supported the efforts to goad, encourage, and fund the attacks on the Capitol, and failed and refused to notify the FBI or other authorities that could have prevented the murders and the damage. Okay, it says here, he swore an oath to, uphold the Constitution, and I guess engaging in any type of political activity now is enough. Okay, All right. Well, they're also saying he misused his taxpayer forms. No legitimate reasons to attack for Cameron to attack the votes on a sister state. This irresponsible action invites other states to challenge Kentucky's voting, thereby endangering the Commonwealth's most basic freedom. So, this is pretty much in alignment with the other impeachments that we've seen. Kind of, very, very much a tenuous connection, I would say, between what they're alleging and the actual violence that took place on January 6th. But you can see where these tentacles are going. They're going into every little aspect of political life. And look, as long as that means that we see more impeachments, I'm okay with that. If Donald Trump was impeached for something as sort of loosely connected as saying a couple sentences that were problematic, certainly Daniel Cameron can be impeached for that. And I would just imagine you could go down the line and make the same arguments for every single elected politician in this entire country. And so if we're going to set the standard where it's at, well, I think it should be equally applied. I like equal application of justice across the board. And that's where we're at. So we'll see what happens with Daniel Cameron. We'll continue to follow that one as well. Now, speaking of the Capitol Hill riots, let's talk a little bit about the police who've been sort of caught up in this whole thing. This article came over from MSN, says the Justice Department and the FBI debate not charging some of the Capitol rioters. What? That doesn't make any sense. Why would they do that? I thought this was like the worst thing that ever happened in this country. Here is the article from MSNBC. Federal law enforcement officials are privately debating whether they should decline to charge some of the individuals who stormed the U.S. Capitol this month, a politically loaded proposition. But one alert to the practical concern that hundreds of cases could swamp the local courthouse, which is, give me a break on that one, okay? Massive, massive break. I don't care if there's 2,000 cases that are coming through that court. They can figure that out. Okay, that is such a cop-out. I don't buy that for a second. We have cases that are just delayed. There's a number of things that you can do. If they're going to have a processing problem, there are statute of limitations on these things that last essentially forever, basically, right? I don't know what the statute of limitation is on a federal sedition case or a federal Capitol, protest type of situation like this, but I'm going to guess it's longer than like 30 days. I'm going to guess it's probably closer to a year. Maybe in Arizona, we have felony charges. The statute of limitations on those puppies, 7 years, okay, which means you could be charged with a crime right now, and if they don't have enough, let's say, resources to bring the charges against you, they can wait 5 years until they have the resources. Then they can charge you. That's what a statute of limitations is. Now, if they exceed that 7 years, then suddenly they can't bring the claim anymore. And this is one of the penalties that the law has in place. They don't want charges to linger over your head for 20 years. They want some sort of bookend so that the timing is finite. They just can't keep, hey, we're still waiting. In Arizona, the misdemeanors are 1 year and the felonies are 7 years. And some are even longer than that. If you're talking about, certain very serious like sex assault crimes, there really is no statute of limitation. So you can bring those charges whenever you want. So here, when they're saying in DC, well, we don't have the bandwidth to handle all of these cases. Well, that's fine. You can just wait 6 months. Okay. Clear out the first round, bring in another round. And if you need to do it again, do it again. So I just don't buy this right out of the gate. And I don't think that that even makes much sense. Let's see what else we can glean from here. It says the internal discussions are in their early stages. No decisions have been reached about whether to forego charging some of those who were involved on the Capitol Hill on January 6th. Justice Department officials have promised a relentless effort to identify and arrest all those. The debate comes at a time when officials are keenly sensitive that the credibility of the Justice Department and the FBI are at stake in such decisions, given the apparent security and intelligence failures that preceded the riots. Federal officials estimate that roughly 800 people surged into the building, though they caution that the numbers are imprecise. A real figure could be 100 people or more in either direction. So sort of as low as 700, as high as 900. Among those 800 people, FBI agents and prosecutors so far have seen a mix of behavior, from people dressed in military battle, moving in formation, to wanton vandalism, to simply going with the crowd into the building. Due to the wide variety of behavior, some federal officials have argued internally that those people who are known only to have committed unlawful entry and were not engaged in violent, threatening, or destructive behavior should be charged, according to people familiar with the discussions. And I think you can have a reasonable disagreement about that. And I've sort of made some similar points to that effect. I think that the people who were sort of at the forefront, at the front line into the building, the ones who were getting combative with the police, the ones who were committing, the violence, the ones who were throwing things and smashing property and injuring other individuals should absolutely be prioritized and they should be prosecuted because of what happened. I'm a criminal defense attorney, but I agree with the equal application of the law. I agree with equal justice. And I think it's a bigger problem when our justice system becomes overly politicized. If either side in this debate can make this a political issue, that's bad for everybody. We've already seen this come out. We've already seen Kamala Harris out there saying, well, there's two tiers of justice here. And this was in response, which I think was unfair, to the allegation that the police just let everybody go, which they did. I mean, that is true. I mean, that's accurate. Now, Kamala Harris knows that she, as a prosecutor, that wasn't over on January 6th. She knows better. She knew that every single law enforcement agency was going to be tracking these people down, and they have largely done that. I mean, is there anybody unaccounted for at this point in time? Another guy just got arrested today. I don't know his story, but a number of people throughout the country in all different parts of the world, I think even Hawaii, they rounded somebody up. The founder of the Proud Boys over there, or sort of the head of that division in Hawaii. Everybody's getting swept up in this thing. And so I think it was a little bit disingenuous of Kamala Harris to say that, they're going to get away scot-free. That's not the case. And her argument was, well, if you shower before work, it's different than if you shower after work. In other words, the blue collar people, they don't get away with it, but the white collar people do. And I thought that was unfair. Not enough time had passed, and the federal law enforcement agencies, the FBI, a number of individuals that we covered on this show have been stating time and time again, they're going to be very aggressive. They're going to be making sure that this thing is swept up as it should be. Because if it's not, if any hint of impropriety comes in, or if there's any indication that one side or the other is getting away from this thing scot-free, then that's problematic. It's going to politicize the system even further. And this is going to be used as a tool to make other adjustments in our society that I'm not particularly comfortable with. So I do think that prosecutions should move forward on Capitol Hill and elsewhere around the country, by the way. People protesting in Seattle, people throwing rocks in Portland, people burning down a police precinct in Minneapolis, they all should be prosecuted. Largely, they're not. And by the way, we covered this last week. Kamala Harris was responsible for helping people raise funds to get bailed out as a direct result of what happened in Minneapolis back last year, in the middle of last year after the George Floyd stuff. So equal application of the law is preferred, and that applies across the board, because otherwise the justice system becomes too politicized, and I do not like that at all. It serves everybody poorly, and both sides will then seize upon the politicization of the justice system to serve their ends. Nobody benefits from that. Conversely, or sort of on a tangent a little bit, should everybody who was in the Capitol building be charged with sedition and insurrection and treason and thrown in prison for 20 years? Of course not. Okay, there were only, I would say, a small, tiny percentage of people who were there who actually did stuff that was truly heinous, who was, very violent, who were injuring other people, who had sort of the idea of a seditionist coup in mind. And the rest of them, I would just say, were sort of along for the ride. And we covered images and stories of both individuals. A lot of people have been arrested, and they weren't even there as a part of the Capitol Hill riots. Cleveland Grover Meredith, I think he's still in custody. He showed up the night after or the day after the Capitol Hill riots, and he was charged with texting, sending some bad text messages. He got into a fight with a pedestrian the next day, and that's what he was arrested for. But he's a Capitol Hill rioter, according to the news media. And so a lot of other people are being swept up in this mega net of law enforcement, and I do not think that all of them should be charged with the maximum. Okay, I think our society is way overly criminalized. What happened in Capitol Hill was heinous. It was gross. I said the word gross probably 50 times on that day. It was gross, and I do not endorse it at all. But I also don't think that we need to throw people in custody for 20 years. We saw pictures of a little old grandma just kind of wandering through the Capitol building going, wow, this is crazy. What's going on here? This is kind of cool. I'll take a picture, take some selfies. It was illegal behavior. They shouldn't have been there. But is that a federal felony? No, folks, that's trespass. It's something where probation is fine. Take some classes. Here's how to engage in civic life. Education is better than incarceration in many cases. I think this is a good one. And just reminder to people, how about you just, use your head a little bit more. I know you got swept up in this big sort of movement, but that doesn't make them seditionists and treasonists. There are some other people, anybody who's responsible for injuring that officer, Sickwick, I think his name is, and was stealing federal property and stuff. Yeah, they can get a little bit stricter of a penalty. But were they really trying to install a separate branch of government or take over control of the government because they took the podium? It's not like Lord of the Rings, okay? We have the ring and you control everything. Is that how that works? I never saw those movies. You don't just take a podium and assume control of the government, okay? That is not how it works. So they were in there for several hours. They were all thrown out, and that's that. So let's go back to the article. The FBI is not charging some people or considering not charging some people. Prosecutors have signaled they're looking to bring charges of seditious conspiracy against anyone who planned and carried out violence aimed at the government. Carries 20 years. Justice Department officials look at bringing those types of cases. They acknowledge those more determined and dangerous individuals may have operated within a much broader sea of people who rushed through the doors but didn't do much else. Prosecutors will ultimately have to decide if all of those lesser offenders should be charged. Nevertheless, the people said some in law enforcement are concerned that charging people solely with unlawful entry when they are not known to have committed any other bad acts could lead to losses if they go to trial. If an old man says all he did was walk in and no one tried to stop him, and he walked out and no one tried to stop him, that's all we know about what he did. That's a case we may not win, which I don't know if I agree with that. I mean, I think that it was probably pretty obvious to anybody who was there, at least based on what I saw, that this thing, you shouldn't have been in there. Okay. If you're wandering around the Capitol and there's windows broken and there's, security guards and I would imagine horns and sirens, and it was madness for a certain period of time. I think you probably knew you shouldn't have been in there. But your defense is, I was just part of the tour, right? It's just part of the tour. Nobody stopped me. It's a public building. It's government property. Everybody else was in there. I thought it was just open, and you could make those cases. I don't know that that's a good defense, but I understand their point. Meanwhile, defense lawyers for some of those charged are contemplating something akin to a, quote, Trump defense, that the president or authority figures gave them permission or invited them to commit an otherwise illegal act. If you think of yourself as a soldier doing the bidding of a commander-in-chief, you don't try to hide your actions. You assume you will be held up as a hero by the nation. Criminal defense lawyers Terry Canfield and Mark Reichel wrote last week. So I think an interesting strategy. I don't think it works. I think if you sort of accepted that defense, you could use that defense for everything. Well, somebody else told me to drive drunk. Somebody else told me to hit that person. And of course, it's not instruction by the president, but those types of claims only go so far. And that's what's going on. Now, the police are involved as well. 2 Virginia police officers posed for a photo during the deadly U.S. Capitol insurrection. The reckoning was swift and public. They were identified, charged with crimes, and arrested. But for 5 Seattle officers, the outcome is less clear. Their identity is still secret. 2 were on leave, and 3 continue to work while police watchdog investigates whether their actions in the nation's capital on January 6 crossed the line from protected political speech to law-breaking. The contrasting cases highlight the dilemma faced by police departments nationwide as they review the behavior of dozens of officers who were in Washington the day of the riot by supporters of President Donald Trump. Officials and experts agree that the officials who were involved in the melee should be fired and charged for their role. But what about the officers who attended only the Trump rally before the riot? How does a department balance an officer's free speech rights with the blow to public trust that comes from their attendance of law enforcement at an event with far-right militants and white nationalists who went on to assault the seat of American democracy? Oh gosh, it's so dramatic. So here's my point on this. We have a situation where you have a lot of individuals who were at a scene, at a rally, and they were there for a political cause. You have a very, 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 very small, tiny, police say maybe 800, maybe 900, maybe as little as 700 who actually went into the building. I don't know how many people were there total. 100,000. So you have maybe just a tiny fraction of those individuals are just not there. Right? They just were not there in the Capitol building and have no connection to it. So if you are law enforcement and you're there a part of that bigger group, of course that's free speech, right? If you're not on duty, if you're out there just participating in democracy, you're allowed to do that. Just because something bad happened in your vicinity doesn't necessarily automatically make you a far-right militant or a white nationalist just by proxy. Okay, that's an absurd argument. Nobody would be able to do anything because if anybody anywhere in this country had an opinion that was somewhat volatile, you're closely connected to that person or even remotely connected to that person, you're now guilty by association. I think that is way too chilling for free speech, and it's problematic for interacting in a way that allows people and citizens to communicate, to talk about democracy, to talk about how we want to govern our country. Now, if you have law enforcement officials who are breaking into the Capitol building or who are contributing to the violence, of course they should be prosecuted, just like everybody else does. And so when Kamala Harris talks about, these two systems of justice, the collars and the showering before work or after work, I think it's a little bit different than that. My big question here is, are we going to see two tiers, one for the law enforcement officials and one for everybody else? Are these cops going to get away scot-free while all of the other people don't? Do they get that blue code? Do they get that blue shield, that little professional courtesy that exists amongst law enforcement officials where everything is just a little bit less severe, a little bit less scrutiny, a little bit more freedom? Their identities are still secret. 2 are on leave, 3 continue to work, right? A lot of individuals who have been charged are not getting those same benefits in their companies or in their lives. So are we going to see the police get away with a bunch of stuff that the other people wouldn't? Probably, because that's just how it goes. All right, so let's change gears a little bit. Let's talk about Rudy. Rudy is in some hot water, just like his former friend Sidney Powell is. They're both being sued by Dominion for $1.3 billion. Now, I know Rudy has been selling a lot of cigars on his show, but $1.3 billion worth? I don't think so. This comes over from the New York Times. Rudy Giuliani sued by Dominion Voting Systems over false election claims. Says that he was engaged in a viral disinformation campaign. Pretty interesting lawsuit here. They sued him. They said he played a key role in 2020. Viral disinformation campaign made of demonstrably false allegations, seeking $1.3 billion, more than 50 statements that Rudy made at different legislative hearings. They're calling it a fictitious narrative. They're saying in a statement released by text message late Monday morning, here's what Rudy says. So let's listen to his statement first. Dominion's defamation lawsuit for $1.3 billion will allow me to investigate their history, finances, and practices fully and completely. The amount being asked for is quite obviously intended to frighten people of faint heart. It is another act of intimidation by the hate-filled left wing to wipe out and censor the exercise of free speech, as well as the ability of lawyers to defend their clients vigorously. As such, we will investigate a countersuit against them for violating these constitutional rights. And I think this is if I could speculate, it's hard to read Dominion's minds, but I think this is more of a public relations effort and an attempt rather than a realistic goal of winning the lawsuit and collecting $1.3 billion. Right? Like, that's probably not going to happen. I don't think Rudy's got that much money. I don't think Sidney Powell has that much money. But what you're going to see is Dominion just sort of making their case. So sort of like what the Trump people did in the election litigation. They were waging 2 separate battles. They were waging battles in the court of law, which they were largely unsuccessful with. And I think there were some problems with that, but they were also playing this battle in the court of public opinion. And so a lot of what they were claiming that was happening in court was being used and amplified in the court of public opinion. We saw that in the form of legislative hearings and speeches and press conferences and all of that stuff. And so Dominion is kind of playing that same game here. They've got a 107-page document. They're alleging 1 count of defamation per se, and it reads like a big laundry list of the wackiest stuff that Rudy Giuliani ever said. So they sort of went through everything. He talked a lot. He was out there, legislative hearing after legislative hearing, podcast, interview. He had his own YouTube show. I mean, he was just on a media blitz for like a month, maybe even longer than that. And what Dominion did here is they just went through and they just gleaned every single, sentence, every single syllable that Rudy ever uttered, and they put it into this massive list of claims that they say are out there, are fringy, are, quote, defamation according to their standards. So let's take a look and see what is in here. We have the actual complaint, and the demand for a jury trial. You can see this was filed today, and it's page 100 of 107. So a very, very big document filed over in the district court for DC, and it's U.S. Dominion versus Rudy Giuliani over in New York. And they're saying the complaint during a court hearing contesting the results of 2020. Rudy Giuliani he admitted that the Trump campaign, gosh, I can't speak today. stumbling all over myself. Rudy Giuliani admitted that the Trump campaign, quote, doesn't plead fraud and that, quote, this is not a fraud case. He was also unwilling to make a false election fraud claims about Dominion. And it's interesting here, they are using this word to categorize everything. He and his allies manufactured and disseminated, quote, the big lie, which foreseeably went viral and deceived millions of people into believing Dominion had stolen their votes. Giuliani demanded $20,000 per day for that, quote, big lie. So if you see here on the screen that big lie is capitalized, capital B, capital L, and they're going to refer to the big lie as sort of this overarching catch-all phrase, that this big lie includes everything that Rudy Giuliani did. They're just going to label that rather than calling it, questions about election litigation or questions about electoral fraud. They're just going to say the big lie, right? They're going to use that just as sort of a marketing, branding, boom, big lie, big lie, big lie, all throughout this entire document. He cashed in, they're saying, by hosting a podcast, selling coins, supplements, cigars, protection from cyber thieves, and so on. They're saying he shirked his responsibility, and they are now suing him as a result. So, the $20,000 per day, quite frankly, I think that's pretty cheap, actually, for what Rudy was doing. I know a lot of lawyers who would charge a lot more than that for that activity. And so, people keep throwing that number around. I just don't think that is anything to be too upset about. But it is something I think worth pointing out, because what we're going to see in the rest of this document is that Rudy is really hustling to turn a buck. And I like capitalism as much as the next guy, but it may have been a little bit close to the grift territory. A little bit close. I don't know what his expenses are like or what this was all about, but most of this I didn't even know until I was reading through some of this. I knew Rudy had a show, and I knew he was sort of hawking, I think, cigars for a period of time. But what Dominion did is they went through and they found like every single thing that he was trying to sell, and some of it's interesting. We have here at paragraph 19, Rudy posted an episode on his podcast where they're saying Dominion stole the election, quote, technologically, and he then, after that, warned about cyber thieves stealing home titles online, threw his arms in the air to emphasize the obvious danger of entrusting important matters to technology. Then he pitched his viewers on a service they could buy to protect themselves for just $5.96 for the 4-year service. And the name of that service was here, promo code Rudy at HomeTitleLock.com. And then also during the same podcast that they claim is defamatory, they're saying supplements would cure your viewers' achy joints and muscles, and implored them to, quote, stop wasting money and switch. He instructed them to now use his name when ordered if they ordered now. So OmegaXL.com. And there's Rudy with a couple pill bottles, selling some pills on his podcast, which gave me a pretty good idea. I mean, would there be any objections if I was hawking, alpha omega defense pills? Hey folks, I'm a criminal defense attorney. I know what life is like in the courtroom. In order to keep my energy high, to keep my stamina pumped, I take alpha omega defense pills. Boom, here you go. Get your bottle for $99.99. Is that inappropriate? I don't know. But Rudy Giuliani was doing it and doing a lot of it. Here's another one. Okay, so they go through. So we're going to skip a little bit in this lawsuit because there's a lot of that. He's selling cigars. He's selling all this other stuff. And they go on to sort of detail about how big his audience is. And it is very, very large. He tweeted out that his YouTube podcast and its ads has more than 1 million followers, more than 9,000 retweets, and 25,000 likes. So he would make these videos and then send them out. They continue on. We'll see here that when we get sort of closer to the middle of the document, that this is where they separated from Sidney Powell. You remember where it was Rudy, it was Jenna Ellis, it was Sidney Powell, and they were all in the press conference when they were talking about this stuff, I think it was our first press conference. And then shortly thereafter, Sidney Powell was gone. She just wasn't there anymore. Trump's campaign statement on November 22nd, Sidney Powell is practicing law on her own. She's not a member of the Trump legal team. She is also not a lawyer for the president in his personal capacity. And Dominion is pointing out, they're saying, well, knowing that the claims against Dominion were false, they declined to sign on to the sham litigations that were filed by Sidney and Lynn Wood. So they're saying that Rudy Giuliani knew essentially that this stuff was bogus and fraudulent. That's why they distanced themselves from Sidney Powell. Even after, according to this document, even after so this is where they're talking about the Antrim, Michigan publication, if you recall, Antrim, Michigan, was where there was a little bit of election questions about Dominion. And there was this report that was drafted by Ramsland. We covered a lot of that here. And then it was sort of debunked. And they're saying, well, even though it was conclusively debunked, according to them, that Rudy was continuing to promote that audit claim. It says people who actually are knowledgeable about election security and procedures in Antrim promptly, publicly, and forcefully rebutted Ramsland's claims. Another claim here, he disregarded hard evidence and reliable sources, including Trump appointees, Republicans, election security experts who rebut and disprove his false accusation. So another one. They are also talking about some trends. So apparently on this day, December 21st through December 22nd, 347 tweets. The reach was 8.7 million, potentially 2,231 users. They were located all across the United States. So you see what they're doing. They're just trying to really sort of build up and emphasize the impact of these claims. They're also going through, they're talking about the gold that he's selling. They've got screenshots of everything. If you call them right now, they're going to give you $1,500 of free silver on your order. And then this is the last page. I skipped a bunch of this complaint, but they're talking about what they're asking for. So compensatory damages, not less than $651 million. We've got punitive damages, another $651 million. Other relief as the court deems to be appropriate. And that's a lot of money, folks. That's a lot of money. Now, I don't have any problem with selling advertisements. I don't have any problem with, making a profitable show or trying to sell ads on your products. I mean, Rudy was doing a lot of work. I think some of his work was on point. A lot of it was not on point. And when we were analyzing it during the election litigation season on this show, we made those appropriate determinations as I deemed to be appropriate. And so, is this lawsuit going to go anywhere? I don't think so. I really don't. I don't think that they're going to. I don't think it's intended to go anywhere. I think it's intended, like Rudy said, his statement here was, it is intended to, to sort of be intimidation. I don't know if I'd use intimidation. I think it's a response in kind. I think it's appropriate. I think that him and Sidney Powell probably knew this was coming and factored it into their strategy. They're both highly skilled lawyers. They know what they can say and not say. I think that really, I'm not a defamation lawyer, but I think that the claim here that suddenly Rudy and Sidney are going to get access to everything in Dominion is too much. May get access to certain things, but nothing that's going to, come out here and shake the foundation of our electoral system. I think that it's just going to be a lot of sort of back and forth. They'll probably agree to some sort of a settlement out of court, and that's going to be the end of it. I don't think that they're going to win $1.3 billion. I think Rudy's, best defense is that he legitimately thought that all of this stuff was worthy of investigating. And I think a lot of it was. I still have a lot of questions about, how far some of this stuff went. Even though Joe Biden won, Joe Biden's the president. Joe Biden's the president, and there's nothing that's going to change that. I've been consistent about that on this show. But the point here is that, I think if Rudy was serious and believed in his case, if he believed that there were some allegations here, and that he has some evidence to sort of support that, if he's wrong, that's not defamation, right? You can make claims about a public company. You can make claims about all sorts of stuff and be wrong. Part of free speech is being wrong. You're allowed to be wrong. That's okay. We want people to be wrong. We'd rather have people say stuff and be wrong about it than be too scared to say anything, because not saying anything is not productive, right? You're sort of just living in isolation in your own little hole or corner of the world. We want more people to be communicating, even be a little bit combative, go at each other. You did this wrong. No, you did this wrong. All right, we're going to duke this thing out, figure out who really did something wrong, and we're going to get to the bottom of all this. And that's kind of what happened here. Now, Dominion, they have a public relations nightmare on their hands. Rudy and Trump has really made this thing difficult for them. I would guess that their business is in a hard spot because we've got elections coming up in 2 years and another one in 4. And I would guess that all of this post-election litigation has really left a sort of a sour taste in many people's mouths as it relates to interfacing with their company. Whether it's justified or not, it is sort of a bad word now, at least for Trump supporters and many Republicans throughout the country. And I don't know that that's particularly fair. I mean, I said at the beginning when Sidney Powell was bringing her claims about the Venezuelan stuff that nobody cares about Venezuela. Nobody cares if Dominion was built in Venezuela. People care about what happened now. not 20 years ago under Hugo Chavez. We want to know now, and they didn't have any evidence to support that now, or they had I would say, very limited evidence to even support that claim. So the Dominion claims always felt a little bit out of left field to me. I thought the bigger questions were the underlying constitutional questions about whether, certain branches of governments can step on the toes of other branches of governments. But now Dominion needs to be very aggressive. This is a public relations piece to say, look, Rudy Giuliani, the key architect, along with Sidney Powell, another key architect of all of this bad information about our company. We're going at them. We're going to ask them for $1.3 billion, and they can take this lawsuit around to all of their different vendors, all of the people that they're doing business with in these state governments to say, hey, we're good. Look, we told you we were good. We're suing them in court. Renew your contracts. Everything's fine. Don't worry about it. Here's our lawsuit. You're going to see we're going to get vindicated in court, and that might help them repair some relationships. But are they going to collect $1.3 billion from Rudy and another $1.3 from Sidney? I'm going to guess not. So I think this is all sort of, litigation theater, which is a interesting way to, to manage your company. And Dominion's right in the middle of it. We'll see where that goes. All right, we're going to finish up with a couple other shorter stories. Let's talk about the impeachment. So impeachment is still underway. I think as I was signing on to this broadcast, there was some indication that the article of impeachment that was written in the House of Representatives may in fact be over at the Senate now. I'm not sure about that, but I think it's underway. They said it was going to be delivered on Monday today, and I just haven't gotten confirmation of that. But we do have some confirmation, or at least strong indication, that Senator Leahy now is going to be the the judge of the impeachment trial, not Chief Justice John Roberts. What? That doesn't make any sense. We saw in the Constitution that when there's an impeachment, we read the impeachment clause on here, 4 or 5 times, that it says the Chief Justice presiding. So if the Chief Justice, who is John Roberts, is not going to be presiding over the impeachment proceedings, what are we doing here? Because it says that we need to do that. So what's going on? Well, according over to CNN, this guy, Manu Raju, says that Senator Patrick Leahy, the Senate pro tem, is expected to preside in the impeachment trial. 2 sources tell me, not the Chief Justice John Roberts. Senators preside when the person facing trial isn't the current president of the United States, per one source. Leahy is still expected to be able to vote in the trial. Leahy tells reporters, quote, "I don't think that there's any senator who over the 40 plus years I've been here would say I'm anything but impartial in ruling on procedure." Isn't Leahy a Democrat? Senator Patrick Leahy looks like this from Vermont. So that's how you know it's a Democrat. This article comes over from the Washington Post. If this were a Republican, it would say R-VT. But it's not. It's a Democrat, so they don't want to tell you that. Senator Patrick Leahy is a Democrat, president pro tem of the Senate. Is that right? Okay, there it is. So they left it out of there. They put it right here. Its most senior Democrat will preside over Trump's second. So I jumped the gun on that. My apologies. But they should have put it right here because that's where everybody looks. We all know that. Will preside over Trump's second impeachment trial that will begin next month. Chief Justice John Roberts presided over Trump's first impeachment trial as the Constitution calls for impeachment proceedings for a sitting president of the United States. So John Roberts was around on the first one, but Leahy is going to be around on the second one. Why is that? Senators preside over impeachment trials for any official who is not currently in the White House. Leahy confirmed the reports that he had been tapped for the duty. When presiding over an impeachment trial, the president pro tem takes an additional special oath to do impartial justice according to the Constitutions. It's an oath that I take extraordinarily seriously. When I preside over the impeachment trial of Trump, I will not waver from my constitutional and sworn obligations to administer the trial with fairness in accordance with the Constitution and the laws. Pressed by reporters about his past criticism of Trump, the senator said, "I'm not presenting the evidence. I'm making sure the procedures are followed. I don't think there's any senator who over 40 years plus has been anything but impartial." All right, so he's 80 years old, first elected in 1974, not said whether he's going to seek a 9th term in 2022. 80 years old, 1974. Oh my gosh, we need term limits so bad. All right, so what is going on here? Well, as we talked about, there's sort of 2 kind of important elements in the impeachment clause that I thought were pertinent. Number one is the fact that the president's still in office. If the president's not in office anymore, my whole thought process here was impeachment is to remove somebody from office. If somebody's not in office anymore, what's the point of impeachment? Same sort of concept we talk about with the election litigation. If you're suing to overturn an election, the election's already been certified. Courts dismiss the election litigation as saying it's moot. It doesn't matter anymore. The election's already been certified. It's done. It's over. We just learned today that Donald Trump had many of his lawsuits dismissed out of the Supreme Court because of the emoluments clause. They were saying, well, he was too enmeshed with his private businesses, and that's an emoluments clause. They're too intermingled, intertwined, and so that's not appropriate. The Supreme Court just got rid of all of them. They said, nope. Dismissed. It's moot. He's not in office anymore. Doesn't matter. Thanks for playing. Okay, so if the president's not in office anymore, what is impeachment for? Well, the response to that was, we don't want him to run again. And it says in the impeachment clause that there is a potential for a preclusion of future office. Very short couple sentences. You can look them up. So, all right. So 2 of those things. Number 1, to remove from office. He's not in office anymore. Number 2, potentially to prevent him from running again. All right. Well, if we're going to do the trial anyways, we got some questions here. Who's going to run the trial? The Constitution says it's the Chief Justice. But they're saying no. Well, Rand Paul was out today over on the Hill. He says, boycott the sham impeachment. And it's a long article. I encourage you to read the whole thing over at the Hill. This was his article written by Senator Rand Paul. And remember, the reason why I wanted to talk about some of these Republican senators, the Republican senators are needed in order to convict the president. Okay, the Democrats have 50 members in the Senate. The Republicans have 50. Kamala Harris is the tiebreaker at 51. You got to get to 67 votes total if you want to impeach a president, sitting or not. So the Republicans need 17 senators, 17 of the 50, to come in and vote to convict Donald Trump. If they can get 17, then that's it. Then he cannot run from office again. So here is Rand Paul, who is a big voice in the Senate, and this is what he has to say. The Constitution says 2 things about impeachment. It is a tool to remove the office holder, and it must be presided over by the Chief Justice of the Supreme Court. Neither one of those things will happen. President Trump is gone. Justice Roberts, properly noticing the absence of an office holder being impeached, is declining to proceed. That settles it for me. There is sort of a third thing in there that I think he's glossing over, which is to prevent future running, to prevent a potential, re-election. That is in the impeachment clause, but the argument here is that there's an and in there. It's to remove from office and prevent somebody from running again. It's conjunctive by one interpretation, meaning it's both. It's to remove from office and then prevent them. So it's removal happens first and then you prevent them. It's not an or where it says removal from office or to prevent them from running again. One follows the other. So you either interpret it one of 2 ways. You either say it's conjunctive, they both matter and stick together, or they don't matter. And it's or. You can impeach for either or. I read it as the and, as do a number of other people, including Rand Paul. And he says here, neither one of those things will happen. This settles it for me. If Judge Roberts is not presiding over this, then it is not impeachment. This charade will be nothing more than a bitter partisanship and political theater. I'm more than willing to work with Democrats to find common ground on protecting civil liberties or ending some of our foreign military interventions, but no unity or common ground will be found if the Democrats are continuing to fight for the last election. This so-called impeachment is a farce, and so on. So that's Rand Paul. So he's not in on that. So they got to find it somewhere else. Senator John Cornyn is now saying unprecedented. This never happened in all of American history, so there isn't a Senate rule or constitutional provision authorizing this. So how does a senator preside like a judge and serve as a juror too? Hashtag conflict of interest, which is a good point. And presumably Senator John Cornyn and his people looked. I mean, has this ever happened before where a president is already out of office and they're impeaching the president to not allow him to run again? I don't recall that ever happening. Senator John Cornyn says that hasn't happened. So, I'll take his word for it. But it does make sense. Okay, if you're a Democrat senator and the judge, that's like insane, right? If you were on trial for a crime and the person prosecuting you for the crime was also the judge of the crime, you would look at that like a laughingstock, right? It'd be a kangaroo court. You would never have any faith in the outcome at all. That's insane. Now, practically, a lot of the judges are sort of working with the prosecutors. But in terms of practicalities, technically they're divided. Probably just angered a bunch of judges out there. It's all right. We have another one from, let's take a look at what's going on in Arizona. So a couple quick stories. This is the Arizona abortion case. A lot of stuff happened over the weekend. So abortion. Listen, if things were not already charged enough on this channel, if you weren't already mad at me for something, it's time to level that up a little bit. So buckle in, buddy. All right, here it is. Arizona lawmaker proposes homicide by abortion bill. Doctors and patients could be charged with murder. Oh my goodness. An Arizona lawmaker known for his hardline stance on abortion has introduced legislation requiring prosecutors to charge women who opt to end their pregnancies and the doctors who help them do it with homicide. Oh my gosh. All right, so well, this is Arizona, folks. Let's take a quick look. This guy comes from Snowflake. His name is Rep. Walt Blackman, Snowflake. Snowflake, Arizona is a very small town, beautiful town, actually, up in the northeast of Arizona. Haven't been there in a long time. Real small town. Is that where Snowflake is? Yeah. Anyways, here's the point. Very small town in Arizona. And he's saying he has vowed to run such a bill late last September, calling abortion clinics, quote, death factories, and saying women who terminated pregnancies need to, quote, spend some time in our Arizona penal system. All right. So here he says, at the time, he shrugged off legal protections enshrined in federal law, arguing that Roe versus Wade is only an opinion and the U.S. Supreme Court should, quote, honor Arizona's sovereignty. House Bill 2650 reflects the view saying county attorneys must pursue criminal prosecutions regardless of any contrary or conflicting federal laws. He says, quote, if you want to spout my body, my choice, you need to spend some time in our Arizona penal system. If you're going to kill and end the life of another human being, that is murder. This legislation, which expands the definition of a person to include an unborn child in the womb at any stage of development, would allow both the state attorney general and the county attorneys to prosecute homicide by abortion. So that is Representative Blackman, just wanting to just throw women, doctors, right into federal or state penitentiary along with murderers. Like same. Okay, so let's take a look at the bill, House Bill 2650, and it's pretty simple, actually. So looks like he's introducing this at the 55th legislature, first regular session, 2021, introduced by, let's figure out who all these people are. Barton, Biasayuchi, we got Bolick, we got Burgess, Carroll, Cook, Fillmore, Hoffman, and Toma, and it's going to be amending all of these different provisions under the Arizona revised statutes. Let's take a look. So what you'll see here when you read our statutes is basically everything in black is already existing and everything in blue is a proposed addition, and then anything in red is going to be eliminated or removed. So they're striking it out. So this is just a proposal of a bill, and you're going to see it's amending a couple different parts of Arizona revised statutes. We've got Title 11 here, prosecution of homicide by abortion. The county attorney, which is our prosecutor, shall enforce Title 13, Chapter 11, and Title 13, Chapter 11, we're going to look at that in a minute. Those are our murder statutes in relation to homicide by abortion, regardless of any contrary or conflicting federal laws, regulations, treaties, court decisions, or executive orders. So that is unconstitutional, I would just say, right out of the gate. The federal government has what's called the supremacy clause. Okay, so the federal Constitution is supreme. It's the supremacy clause for a reason. So if you have the federal government and a conflicting state government that have rules or laws that are at odds with one another, guess which one wins? The federal government does. Okay, we all know that. Sometimes that's a little bit unfortunate, but in this case, I think that's probably a good thing because this guy, I don't know what the hell he's doing. He says here, in relation to abortion, regardless of any contrary or conflicting federal laws, we already know that is not okay. We've got under subsection, this looks like Title 12, they're defining that nothing changed there. They're adding subsection B here. It says, for the purposes of this section, person includes an unborn child in the womb at any state of development. So they're looking to amend that. And then the place of trial, they're deleting a couple of the ors. All right, so let's take a look at that's the law, right? That's the provision that he's looking to introduce. Very, very, very limited, but they're looking to amend this section. So 13109, Well, here are the murder statutes. So these are the definition of murder in this chapter, unless otherwise requires. The definition of a person means a human being. So presumably, he sort of wants this to carry over to include an unborn child in the womb at any state of the development, although this is a different section. So they're not actually amending 13.11.01, they're amending 12.6.11. Then they're talking about first-degree murder. So let's take a look and see if this fits. A person commits first-degree murder if, intending or knowing that a person's conduct will cause death, the person causes the death of another person, including an unborn child, with premeditation, or as a result of the death of another person with premeditation causes the death of an unborn child. So that's our existing murder statute. And what that is saying is if you kill a pregnant woman, you're also responsible for the death of her child. All right. And that's what that statute says. But if this congressperson's bill goes into play, then presumably a woman does not have to die personally. If she goes in and has an abortion, you could charge the woman with murder. You could charge the doctor with murder. Theoretically, I would guess that you could, the statute is so vague, could charge everybody else in the abortion clinic or the Planned Parenthood clinic or whatever with murder. So just a totally ridiculous thing through and through. That's all the commentary I have on that. Let's talk about a couple quick things before we hop off. Well, we got our super chats lined up. One more story I wanted to share with you before we hop off, before we get to the super chats is, there's this, last week I was pretty upset about the purge that has been going on as it relates to free speech. I am a big proponent of free speech. I like a lot of ideas in the marketplace. I think that even dangerous speech should be protected. We want that out in the open. We don't want it underground. We don't want it, sort of buried away, tucked in the corner. We want it open so we can see it, we can identify it, we can know who's saying it, and we can repudiate it. We can address it. We can combat it in the arena of ideas. Last week, we got canceled from a chat server, which we're still trying to sort that out. And, we saw sort of the purge of a lot of other platforms. We saw Parler disappeared. We saw Trump off of Twitter. We saw YouTube, sort of eliminating people. A lot of QAnon accounts were gone. A lot of the, white supremacist people were gone. Everybody was merging over to Telegram and Signal and MeWe and all these other places. And, it was kind of all quiet. People were sort of kind of happy about it. A lot of people that I follow on Twitter were saying, well, hey, they shouldn't have been so conservative and they shouldn't have been so right wingers. And, it's only them. Well, it's not. It's not only them. It's not only the people who you disagree with. What we're seeing, I think, is a consolidation of the media and the conversation to support the existing establishment, and even anybody on the fringe, it doesn't matter what side you're on, they're being shown the door. And we saw that. This article came over from WSWS.org. It says the Facebook purges left-wing pages and individuals, not just the right anymore, everybody. On Facebook, on Friday, Facebook carried out a purge of left-wing, anti-war, and progressive pages and accounts, including leaders of members of the Socialist Equality Party. Facebook gave no explanation why the accounts were disabled or even a public acknowledgement that the deletions had occurred. Screenshot here from somebody. Your account was disabled. If you think it was done by mistake, let us know. Going to be permanently gone. At least half dozen leading members of the Socialist Equality Party had their Facebook accounts permanently disabled. This included the public account of Genevieve Lay, National Secretary of the International Youth and Students for Social Equality, and the personal account of Niles Nymuth, the U.S. Managing Editor for the World Socialist website. 2016 Socialist Equality Party candidate for U.S. Vice President. Also disabled a number of other groups. London Bus Drivers Rank and File Committee, Socialist Equality Party over in the UK, widely discussed call for a walkout by bus drivers. We've got none of these individuals who accounts were disabled had violated Facebook policies. Upon attempting to appeal the deletion, they received, "We cannot review the decision to disable your account." No explanation, no warning. Effectively seized the intellectual property of those it had targeted, cutting them off from years of their photos, writings, and online discussions. It's terrible. It's just terrible. It's terrible across the board. It's a shame when they do it to the right people. It's a shame when they do it to the left people. I have no love for the socialists. I have no love for, communists or any of those things at all. I think they're not good. But I believe in their ability to organize and to speak and to participate in our country, in our government. And so, it really, really just irks me that it's happening to people on the other side of the aisle. I don't agree with the socialists, but man, I will fight for them to be able to say it. And I want these conversations out in the open. Had I even known that there was a Socialist Equality Party on Facebook, I might have checked them out. What are these people talking about? But I'm not going to be able to do that anymore. Fortunately, I think there are plenty of socialists around the United States and other more popular mainstream sites, but they're not going to get canceled. The point here is that it's happening to both sides. And so if you are, somebody who is sort of basking in glory to see all of the Republicans and right wingers thrown the door, it's just a short time until the other side of the aisle is no longer useful, is no longer something that fits the narrative. And we're just going to see, sort of the fringe elements just constantly pushed away as the media, big tech, big pharma, big military, big government, all just create this nice little safe protective bubble in which we can all operate in. Because anything outside of that is dangerous. It's just nice and safe in here. And that bubble is just going to continue to shrink and to shrink and to shrink. And it is very concerning in my humble opinion. So let's take a look at some of the super chats. Oh, we've got a few of them coming in. Our first one to start us off is from our one and only Miss Sharon Quidney. Says, how is it possible to charge a person with double homicide if a pregnant woman has been killed, but not in the case of abortion? How is it that one can be a person and can be murdered in one case and not in the other? So, Sharon, you're asking me a question that's way above my pay grade on that. I can't tell you personally when a person is a person, but I can tell you that all this stuff is policy. That's how. It's just a matter of policy. Okay, and so literally, it's what the laws say the laws are. And so in Arizona, they're making the claim here that if you have something in your womb, that is a potential human life that counts, and that's what this guy's arguing. And so they're saying from the moment of inception, any damage to that embryo is akin to homicide. I don't know. We got Scotch says, hi, Rob and Miss Faith. If Sydney and Rudy don't have that kind of money, what happens? It's obvious they are exacerbating damages and trying to ruin them. I think so also, Sach. It is very unlikely that I think that they're going to recover any of those damages. I mean, practically what you could do, let's say Dominion is successful. They succeed in their claim and the judge goes, yeah, 670 million for punitive damages. That sounds right. 670 million for compensatory damages. Yeah, that's about fair. Then they could just issue an order for them and they could, garnish their wages, seize any future assets that they come into. I don't think that's likely to happen. I agree with Rudy's characterization of it. I think Dominion knows what they're doing as well. They know that it's a chilling effect. They want to hit them with a big number. They want to make a big public spectacle about it so that nobody else thinks about questioning them in the future. And, it's a PR battle. I think that's all that it is. Another one we have from Beth Coddington says, hey, happy Monday, Robert and friends. Check out my last post. The mystery is solved. Racism caused the climate crisis. Such a relief to finally know. So Beth, you must be talking about your post over on Locals. I will go take a look at that. Racism is kind of responsible for everything now. I mean, like everything. So it doesn't surprise me that it's also causing the end of the world. We have Turd Ferguson says impeachment version 2021 means any federal civil office holder can be impeached as a preventative move so they can never hold office again. Hope Trump starts the impeachment party. Make impeachments great again. Yeah, listen, if Donald Trump needs a campaign chairperson for the impeachment party, I would like to volunteer myself. And Turd, I'd like you to be the deputy campaign chair. All right. Because I think we can really move the ball forward on this thing. And listen, I think this could actually be a winning formula. And I'm only kind of half joking about that. Right? Most people hate Congress. Congress has like a 13% approval rating. Now, the only rub with the impeachment party, which is a pretty big problem, is that you need Congress to vote to impeach themselves. So, I'm not sure that we can get that done. In other words, if I walked into the halls of Congress with 550 impeachment articles, I need some people to vote for some of them in order to get them through. And so that's a difficult calculation. I'm sure you could come up with an algorithm or something. Maybe you could get everybody to vote, to vote to impeach for just a handful of people, and then you can. I don't know if you could change anything that way. Maybe a convention of the states is a better idea, but the impeachment party, it just feels good. And I think you're right, Turd. The standard is so low, you can impeach anybody. We have JBB777 says Stephanie Murphy to introduce a bill to disqualify participants in Capitol attack or members of QAnon from holding security clearances, which is disturbing. I agree with that. So this is sort of a law that's passed after the fact where something it's unconstitutional. You're not allowed to do that, where you just say, all right, after the fact, we're going to pass all of these restrictions that you didn't know about before the act, right? It's like, a rough example would be, well, you drive on a road and the road is 30 miles an hour. You've been driving it for a long time. You know it's 30. Everybody knows it's 30. One day the police make the speed limit 10 miles an hour. And they just say, oh, well, you're going 30 on a 10. And you say, well, I had no idea about that. And they just changed the law right in front of your eyes. And or let's say you were going 30 on a 30. This is a better example. You were going 30 on a 30. You don't get arrested for that. And the next day they change the speed limit down to 10 miles an hour, and they show up at your house and they say, hey, yesterday we saw you going 30 on that 10 mile an hour road. And you say, yeah, I know it's 30. It was 30 yesterday. And they say, well, it's 10 now. And so we're going to write you a citation for that because you broke the law. Well, you say, well, it wasn't a 10 mile an hour speed limit yesterday. And they said, yeah, but we just passed that. It is now. And now we're going to penalize you according to these new rules that you didn't know about. And you can't do that type of stuff in criminal law. Now, the rub here is that it's not criminal law, right? This is sort of discretionary security clearances anyways. The federal government, I think, could probably have those very fluid. They could say, all right, well, we have this new extremist group that just popped up. We had no idea about it. And so we're going to modify our security clearances to accommodate these new developments. Here, Stephanie Murphy might be saying this is a new development. I still think it's problematic. Members of QAnon, anybody who participated in the Capitol attack, so if they were, storming the building, that I can agree with, but that's not what we're talking about in many of these things. It's a much bigger bucket, and I don't like how they're using a small contingent of malfeasance to impugn an entire movement. It's troubling. George McNair says, if Dominion does go forward with the lawsuit, doesn't Rudy and other defendants get almost all the discovery they want, including the machines? So, George, no, unfortunately, it's not something that is that broad. I know that Rudy and Sydney have been making that statement a lot, but it's just not. You have to talk about the scope of this. And, I think that they would be inclined to ask for it. I think Rudy and Sydney will probably ask for all of that. Is a judge going to grant them open access to everything? No, because it's just outside the scope. So it'd be like, if we're representing somebody in a DUI case, government says your client's guilty of DUI. We say, no, he's not. And we say, well, we want to check the crime lab. We want to go through the crime lab and look at your gas chromatography machine. And the judge is just going to say, oh, okay, no, you're not allowed to do that. And we say, well, why not? We have all these questions about it. And they're going to say, okay, well, that's fine. You can ask their expert about it. You can ask them about how it works, but you don't get to go in and just start deassembling the machine and that type of stuff, because it's just not how it works. You just don't have sort of unfettered access to their entire file. Now, you can go in there and you can look at their certification and their accreditation, and you can interview their experts, and you can subpoena all sorts of manuals and stuff. You can really dig into it, but they're not going to give you everything that you want. And in fact, many judges in Arizona just say, no, you don't get any of that stuff, right? You only get this, that, and that. And the judges have a lot of discretion to craft how discovery happens, how this equal exchange, and stuff needs to be relevant. It needs to be consequential, or else the judge is just going to say, no, they call it a fishing expedition, and courts don't like that to happen. You don't just get to go cast your rod into the pool and see what comes out. You have to be very specific and focused. Otherwise, these types of claims can just spiral out of control and just get off track, and the judges won't allow that to happen. Got another one from Sammy Elliott. They need 17 GOP to vote to impeach. Doubt they can. I agree with you, Sammy. I don't think that is likely. If they did, man, that would be a catastrophic hit to the Republican Party, which may not be that bad of a thing. We have Turd Ferguson says incitement to erection is hard to prove. It's hard. So, Turd, some people would look for visual evidence about that, but I certainly wouldn't be interested in seeing it. We have Brian Reinhart says, it's no different than evicting a tenant who already left. Yeah, that's a good analogy there, Brian. I think that's fair, right? Why would you go through the eviction process? And to extend that analogy further, the next question would be then, well, what about if you wanted that tenant to move back in? Don't you need to go through the eviction process just to make sure that they can't ever move back in? Just to make it clear, put it in law that we had the hearing and that they're not allowed back in. Well, the response is no, you just don't let them back in. When they come and try to apply for that building or for that lease, you just say, no, you're not allowed. We're not going to rent to you. We almost had to evict you last time. We almost had to, but you left. I think the analogy works. We got Wolfgang Deo who says, yawn. Oh, hey, it's 5:30. Stretches out a little. Hey, y'all. Looks like the trolls finally went away. Slow mode is not on. Nice. Good to see you, Wolfgang. Welcome. Hope you had a nice little nap or a nice morning wherever you are. We have Faye Spurlock, the storyteller, says, wow, I have a sinking feeling the charges for the January 6th Capitol Hill will for sure stick to the right-sided folks. The others will get off. And it's a prediction, says Faye Spurlock. Yeah, we're going to see, we've been sort of keeping track on some of these cases as they're going forward. We now have a couple different buckets of individuals. We've got the one individual we talked about on the show was former BLM. I'm not, they kind of disavowed him from their group. I think we had a couple other people who showed up after the fact. We have another person who was there on the day of, and then we have these other cops. Right. And there's some differences between the two and how they're all being handled. Now, some of this is sort of hard to flesh out because of the nature of how this is working. And remember, a lot of these people are sort of going back home and they're getting in trouble there, or they're getting extradited back into the DC area. And so there's a lot of moving parts here. It's hard to identify any patterns at this stage, but I think as we progress in this litigation, we may get to see some patterns. And more specifically, I'm looking at the end case dispositions. Who got what outcome for what types of charges? And are we able to see any differences from within that bucket? Another one from Beth. I'm sure grandma and others are full of regret. Yeah, I think so. I think a lot of people there just got caught up in a frenzy, got caught up in a moment. I'm not excusing it, but I also don't think it's sedition, because it's not. We have Turd Ferguson says, if a DA sends a letter stating declination to charge or to prosecute, to what extent is that binding? Does that create a reliance right for the individual? Good question, Turd. So I've never seen it in that frame before. So I've never seen it, when in my experience, I've never seen a prosecutor, I would say, go back on a non-charging decision unless something else pops up, right? So they may investigate. So the way that so a good example would be like in a sexual assault case. So what can often happen would be some person, let's say a member of a band, okay, or somebody who's a part of an organization, they get sort of roped up in a bad situation. It's an allegation of sexual assault. A lot of conversation about whether that was consensual or non-consensual. So you have a defendant who's being investigated for sexual assault, for rape, right? And the defendant is saying, no, it was totally consensual. And the other party, the victim here, is saying, totally not consensual. And there's no real evidence one way or the other. Kind of a he said, she said situation. And so the defendant is being investigated, and they contact a lawyer. They're freaked out. Hey, I got this detective here, and they're asking me to come down. And we say, nope, you're not allowed to do that. We're going to go down with you. We're going to talk. And we, invoke and say we're not talking about anything. We contact the prosecutor, who's now part of the pre-charging bureau. They're considering what to do with this case. They're saying, all right, well, our detective is here and all this stuff, and our guy's lawyered up, so we're not talking. What are you going to do with this case, prosecutor? They say, all right, well, look, we've investigated it. We're not finding any evidence of physical, abnormalities. We're not seeing any scratches or bruising. We're not seeing any tears. We're not seeing any of the, more gruesome stuff that you typically see in a rape case. Therefore, we're going to decline to charge. Okay, great. That's fine, because our guy didn't do it. This person has buyer's remorse or whatever, and that's it, right? This happens a lot, by the way. If you think this is something that doesn't happen often, it happens all the time. So, okay, goes away. Now let's say we fast forward 2 years from now, and same situation. All right. So same defendant. Now there's another woman, and it's the same set of facts. Okay. The reason I said, you can pick a profession like a band, right? So if somebody is now, sort of picking up people who were there and following, sort of like groupies who would come back to his hotel room or her hotel room or whatever. And it's the same set of facts, and it happens again, and it's the same victim with the same story. Now a prosecutor who previously decided to decline those charges now may wake up and go, it happened again. And now they're going to connect the two. Same story, same facts, same location, same allegations. And then now they can make a case off that. So they would basically say, no. So they said that they're going to decline to charge the first one, but they're going back on that. They're going to charge it in conjunction with the second one. So you would kind of need something else. I haven't seen a case where they said that, we're not going to charge you, and then they wake up on a Thursday and they charge you. So, a reliance right would say, well, they got a letter saying we're not going to charge, and then they went and did something. If they went and did something like left the country, started a business, and the prosecutor decided to charge them, I think you're talking about two different areas of law. So I don't think that person would then be able to go and argue in a court of law that they breached their contract to not charge me with a crime. The criminal charges would supersede any sort of reliance rights you would get out of a contract theory. Very good question. Very long answer. Good to see you here, Turd. Another one from Liberty or Death says, I don't think I would take your alpha omega defense pills, but how about your crim pro and evidence outlines? By the way, facial hair, too perfect. I impeach you. So Liberty or Death. Yeah, my crim pro and evidence outlines, those are pretty good. Yeah, I'd be happy to offer you the Crim Pro Omega Alpha Brain. Alpha Brain, is that Rogan's thing? So yeah, so it's, Crim Pro and evidence, those are pretty good outlines. I'd be happy to, I don't even know where those are anymore. You know how long it's been? It's been so long. You do not want my family law outlines though, or contracts. Okay. Those classes were the worst. Good to see you, Liberty or Death. We have Leslie Tonkin. If anyone can be charged for just being there and called a domestic terrorist, what happened to Ted Wheeler in Portland when he was out with Antifa? Ted Wheeler, perfect impeachment party. Perfect. Hey, by the way, somebody messaged me on Twitter. Did I tell you this last week? I think they're working on a web app for the impeachment stuff. So it's just outstanding. So it's going to be hilarious. Yeah. Ted Wheeler, impeach away. I mean, he was out there sort of getting right in the middle of it with Antifa. I mean, you could basically say that's insurrection right there. We have Beth Coddington also saying, I'll believe Dominion was remotely harmed when the U.S. outlaws all of their voting machines, which will never happen. Yeah, it won't. What I was thinking is that I was just reading the next one. I was thinking that Dominion would change their name or sort of reorganize, not use that name, change into something else, and probably just keep on skidding through. We have John Crute says, I don't personally see how Biden's master plan of equity over equality over the next 4 years is going to unite the country. I know that you could probably do a whole show on the subject, but any quick thoughts? Yeah, John. Yeah, this is something actually that I've been trying to wrap my head around. I was talking to Miss Faith about this, and actually some other close advisors in my life about some of this stuff. It's very, very volatile. So what John is talking about specifically is this difference between racial equality and racial equity. And on Locals, I posted a story over this weekend from Andrew Sullivan. It has a brilliant article about it. And he's talking about this idea and the difference between the two and how many Americans are just so sort of, they'll gloss over the difference. Well, racial equity, I believe in racial equality. And so racial equity sounds, it's pretty close. So clearly I would be in favor of racial equity, right? I mean, who's not in favor of racial equity? But it's a different concept. And we're talking about sort of equal opportunity versus equal outcomes. It's a big difference, saying that everybody should kind of start at the same place so that they have the same opportunity to achieve the same things in their lives. That gives that segment a bit of a personal responsibility and a bit of incentive to do something with their lives and to make something of themselves. On the other side, when you're talking about racial equity, it's a little bit different now. It's saying, okay, we're not giving everybody the same starting point. We're going to make sure they all end up at the same place. And so if that means we got to take some from this bucket and give it over to this bucket, then that's what we got to do. And it's based out of racial equity. And so I do have a lot of thoughts on it, but I'm just sort of, I'm not sure if it's something I want to get into too much. I haven't thought it through clearly yet. And quite frankly, I'm still educating myself on it. I mean, I've learned a lot about it very recently because I started to hear this phrase bubble up more and more: racial equity, racial equity, racial equity. And I thought, that's different. I'm hearing some other language from the Biden administration about, and I posted about this on Locals too, about domestic violence extremism. And they're merging domestic extremism with domestic violence extremism. And I know that sounds like a nuanced, sort of piddling little distinction here, but I think it's pretty important. And I sort of laid out some thoughts on that. But yeah, John, the racial equity stuff, I think I might broach that subject here. I already made a slide about it, but it's kind of provocative stuff. And I'm just not sure that I'm comfortable actually, talking about it yet until I learn a little bit more about it and see how it continues to play out. But it is something I think we're going to be hearing a lot more of. And so just as a general foundational concept, there's a difference between racial equality and racial equity. And if you don't know what the difference is, go check out that Andrew Sullivan article. I think I linked to it. It's on Locals. I linked to it, and I think it gets you past his paywall, unless he turned it back on. Good question, John, and I'm going to see what I can do about that. We have another one from Curtis Bartle. Says they just make it up as they go. The people should be able to vote on all changes. What gives them the right? Well, I'm not sure what we're talking about in terms of the changes. What did we talk about today? Well, I don't think it really matters, Curtis. I think you're right. People do need the ability to participate. We have the Wandering Mariner says Walk Away campaign founder Brandon Straka charged in connection to the Capitol siege. I'm guessing that can be in tomorrow's show. Keep on keeping on. Yeah, I saw that. So Brandon Straka, I actually follow him on Twitter, and he's pretty vocal. He's pretty active. And so I'm curious to see. I saw the headline there, The Wandering Mariner. I haven't looked into the story at all. Probably will cover it on tomorrow, sort of skidding in here as that story came in. So I'd be curious to see what his role is. He's a big voice out there. And he was somebody who used to be a Democrat and then sort of led the walk away movement. I believe he's a gay man. He said that very recently when he was repudiating Kathy Griffin. I actually saw him this morning talking about Kathy Griffin. Kathy Griffin was saying, "Hey, why is everybody so mad at me? What did I do with Trump's head? What was the problem with that?" And he kind of blasted her, and I was like, "Hey, good for him." So it's going to be curious to see what happens with his case and all of the others. We have Faye Spurlock Storyteller says, "I can only say I'm old enough to remember when abortion was illegal. Women got butchered and died, often getting an illegal abortion." Yeah, that sounds awful. I don't have a lot of commentary on the abortion stuff. I largely kind of stay out of that issue. And I can tell you this, though. I do not like the idea of that, Faye. That's terrible. And the idea of just locking up women and doctors in prison for homicide is also insane. So hopefully that goes nowhere, and it won't. AL says, if it's or and not and, why would you say impeach a president and allow them to stay in office but not run again? Their argument makes no sense as or. It's a great point. It's a very astute observation there, AL. Yeah, so if it's an or, then it means it's disjunctive, and you can just sort of skip over the remove from office part. You could say we can do impeachment to either one, remove from office, so follow the bouncing ball, beep, or we can do impeachment to prevent them from not running again and just skip over the removal from office, which doesn't make any sense. One necessarily would follow from the other. A prevention from ever running again would follow removal from office. If you're not going to have the removal from office part because you're not in office anymore, then the contingent prevention of running is not applicable. Very astute observation there, AL. Thanks for sharing that. We've got Sally Sucka says, Chuck Schumer says, quote, disclaimer, if rioting causes an erection lasting longer than 4 hours, seek immediate medical care right away. Yeah, when we get into the heat of the election, somebody's got to keep an eye on Chuck Schumer. Okay, because we don't know how excited he might be come February 8th when this impeachment trial starts. If he's looking a little bit, flustered, if he's over there just kind of fanning himself in the corner, somebody get that man an ice pack. We have another one from Seiji Takahara. Says, how low is, quote, incitement insurrection? If the left is offended by your death and goes rioting, now you are guilty of insurrection. It's very, very low. Yeah, are you talking about... if you can be offended about anything, I think, then that's inciting insurrection. I mean, they're using it in Daniel Cameron's case as well. Daniel Cameron was a part of a Republican Attorney General organization. Insurrection. Yeah. It's pretty fun standard. We have Renee Markov says, what book are you currently reading? Very good question there, Renee. 2 books. Do I have them here? So the way that I read books is very, there's no real pattern to it. I like to dabble in a lot of books kind of simultaneously. So let me show you what I have here. This is the stack that I had brought out from when we did the existence systems. So here's a couple good ones. Okay, we've got, of course, the Federalist Papers, which I flipped through. I've got Meditations by Marcus Aurelius. We've got A Breath by James Nestor. We've got Tiny Habits by B.J. Fogg, and The Road Less Stupid by Keith Cunningham. I've read all of these, and they're all outstanding. I am reading currently. I'm actually reading one with Miss Faith. We're reading the Naval book, so the Almanac of Naval Ravikant. Excellent. It's free. Just Google that. Excellent book. Very, very good. And I'm also reading, I think I read this one or listened to the Audible a while ago, but The Power of Now by Eckhart Tolle. Rereading that. I think that one is something that is very good from a mindset perspective about just understanding the power of sort of living in now, living in the moment, and recognizing that you're not you're not your mind. You are not the thoughts in your mind. And it's always good to remind yourself to get out of your head a little bit. And that book is outstanding at helping me do that. So the Almanac of Naval Ravikant and Eckhart Tolle, The Power of Now. What's on cue, what's on deck is the Taleb, Nicholas Nassim Taleb. He's got his whole Incerto series that has The Black Swan, Anti-Fragile, and I think 2 other ones. I have dabbled in The Black Swan and I've dabbled in Anti-Fragile. And the one that I have not read from him is Skin in the Game. I really want to dive into all of those. 2 of those I listened to on Audible, and I just didn't get enough out of them. They're so deep that it's something I got to sit down with a pen and read. I just can't listen to it. A good Audible is A Breath by James Nestor. It's good. And that book, breathing I'm not joking about this. Breathing correctly has changed my life in 6 months. It's crazy. 4, 7, 8 breaths. 4 breaths in, 7 breaths hold, or 7 counts hold, 4 counts in, 7 counts hold, 8 counts out for a cycle of 4 times. So 1, 2, 3, 4 in, count to 7, hold, count to 8, exhale. So you're exhaling on 8 counts. 4 cycles of that. You do that twice a day, 1 in the morning, 1 at night. It will help you sleep better. It will help your libido. It will help your anxiety. It helps everything. Just try it and look up. The guy's name is Andrew Weil, W-E-I-L. He's the father of integrative medicine. He has a video, or go watch my Existence Systems video that I did on January 1st this year. Very good stuff. And thanks for asking about that, Renee. It's a problem question because I'm reading a lot. I like to dabble. And there's a lot of good stuff out there. We got Nano Bingo says, is discovery possible if Rudy gets to court? Yeah, definitely. So they're going to be asking for discovery. He's going to be asking for discovery. I think that it will, unless it settles out of court, or unless, I think one of those 2 sides will probably file a motion for summary judgment. Honestly, I think that these are mostly public relations lawsuits. I'm not expecting much substantive law to come out of it. We have another one from Sally Sucka. Says, I do a podcast that airs every Sunday at 3:30 p.m., 6:30 p.m. Eastern time, called To the Point on Facebook with a head host on current events. It's sort of like a conservative version of The View. haven't been silenced yet. So there you go, folks. Go check that one out. So over on Facebook, it's called To the Point, with a head host on current events. I'll have to check that one out there, as should you. Thanks for sharing that with us. We got Cheryl Meyer says, Arizona Senate is pursuing forensic audit of Dominion equipment ballots. If audit results verify Dominion hanky-panky, can Rudy use that evidence? Yeah, I think he could. He certainly could. Yeah, truth is a defense to defamation. If Dominion says, you lied about us, and Rudy says, no, I didn't. This is the truth. Here, everything's corrupt. Here you go. It's a pretty good defense. So if Rudy has something to that effect, he can definitely use that. Thank you, Cheryl Myers. We have Sally Sucka says, my neighbor's dog that barks constantly irks my nerve. I'm going to bring articles to the Senate and have her impeached. Impeachment fashion trends 2021. Yeah, so impeach her easily, because the dog barking, I'm sure I've had a neighbor like that one time. I certainly felt like insurrection. You know, I would insurrect anything and everything. I would insurrect with haste and diligence to eliminate that. So, you know, I think you're in good company. Her dog is causing you to feel insurrectionist. She is inciting your insurrection. I say impeach the hell out of her. We have Adam S. says, so was Rudy and Kraken on a fishing expedition? Yeah, I'm not real sure what happened with the Kraken. You know, they kept promising the Kraken. We never got the Kraken. And they were probably trying to find something, and they just didn't get much of anything. That was from Adam S. Thank you, Adam. We have Seiji Takahari. He says, glad I do not live in America. I'm getting a very bad feeling about how things are trending. Looks like a lead up to Masada in about 77 AD. So I'm not real familiar with that in 77 AD there, Seiji. I need to brush up on my history on that one a little bit. You know, America's not a bad place. Our news is pretty awful. It's pretty bad. You know, if you go around to any news site, it's just like death and destruction and dreariness just across the board. But largely, America's a pretty good place. I mean, we have a lot of very nice things here. We're very fortunate in many, many ways. And oftentimes I think people complain a little bit too much about it. It's funny. We was just talking to a very nice lady today. Somebody who, you know, we spend some nice time together as significant people. And we were talking about Arizona was raining today. Very, very beautiful out there. And we were just sort of both pointing out the fact that this is a very nice place. You know, it's pretty beautiful. Arizona gets dumped on a lot because it's deserty and dry and hot, but it's, you know, it's pretty great. Sometimes it's nice to pause and sort of just feel a little bit grateful for what we do have, which is another big important point. On my existence system, there's a whole box for gratitude. Gratitude is the greatest vibrational frequency in the world. So get yourself into that state. And Seji, come check out America if you've never been here before. Cheryl Myers says, if you have dead Congress members to vote to impeach all the live ones, your impeachment party will be a success like the 2020 election. There we go. We have it. We have an answer. So all we need to do is just go round up. It's basically true. I mean, we can basically come up with anything we want. We can find the votes, Cheryl. I know we can. You've given me new energy and gusto. I appreciate it. Hugo Munoz says, what happened to the Russian 2016 interference files? Yeah, I don't know what happened to those. Where are those? Did Trump declassify those? I know he declassified some stuff, and I know a lot of people were really combing through it, but I don't recall whatever came of it. Thanks for pinging us on that. We have Nano Bingo says, if the suit accuses RG of defamation, isn't 11-6 performance of D Machines the crux of the suit? So RG, when I think of that, when I see that, I think of myself because I'm Robert Gruler. But I think you're talking about Rudy Giuliani, which is the lesser of the RGs. There's only one RG in this world as far as I'm concerned. You understand that? And he says here, if the suit accuses Rudy of defamation, isn't 11-6 performance of the defendant's machines the crux of the suit? Sort of. So sort of. If you read their actual lawsuit, they're going through sort of paragraph by paragraph and addressing every one of Rudy's specific claims. So it's not as, I think your point is right there, Nano Bingo, that this is this is the main theme. Obviously, they're talking about the performance of the machines, whether they work or not, whether they're accurate or not. And so they're sort of going through, if you read it, it's 107 pages long. It's paragraph after paragraph after paragraph. And so they'll take one, they'll sort of dismantle that claim or connect it to other things. Here, their argument has largely been that it's just a grift. He's sort of out there talking a lot of meaningless words, fraudulent this and stolen that and all that, but there's no real hard evidence that would connect it to any indication that there's problems with their performance. And, I think it's kind of splitting hairs at this point. I think that Rudy can make his claims, Dominion can make their claims, and neither side is going to see any movement or any momentum one way or the other. And it's largely just a political public relations spectacle at this point. If Rudy thinks that the judge is going to give him access to, let's say, Dominion's entire file system or give them access to a machine, I just don't think that that's likely. I think a judge is going to say, no, that's outside the scope. We're talking about defamation here, whether Rudy was maliciously lying or acting with actual malice. And I don't think that you can say that about Rudy. I think he had a pretty genuine belief that there were some problems. A lot of people believe that there were problems. Even, people like Rand Paul and Josh Hawley and Ted Cruz and senators and, other attorneys generals. We saw a lot of people sign on the Texas versus Pennsylvania lawsuit. So, there's a lot out there. And I don't think that Rudy would be totally off base by saying, I've got questions about that. Whether his conduct sort of crossed the line into a reasonable belief versus actual malice. Actual malice in a defamation suit it's a high standard. I mean, you got to be out there really aggressively malicious against somebody. You can make the argument that he was, but if he had his beliefs rooted in some sort of basis, which I think he can make an argument that he did, I think he's going to be okay. And so he's being sued. So his response is going to be, no, I didn't meet that standard of defamation. And if the judge sees that, that's the end of the lawsuit. It doesn't suddenly become, okay, so now that I don't think you met that standard, I'm going to open the books for all of Dominion. I think it's going to be disposed of before we reach that next stage. Good question, though, Nano. Toots Magoots says, how many platforms are you on? Do you mind telling me about your book? So, Toots, we are on just a couple of them right now. After the show, I upload this to, where do I upload it to? Rumble. And I upload it to an audio version. So it's on podcast, I think on iTunes and on all the other big ones. So just the audio is on that. We are not on officially Gab yet. And I mean, I'm officially on Gab. I don't use it. I haven't created anything on MeWe. I'm on Twitter. And that's kind of about it. I was just talking to Faith about this. I think we are going to be diversifying our platforms a little bit further. Locals is kind of the next home base. We really, really, really want to push locals. And it's not just for my vanity. It's because if we get over 1,000 members over there, then I think we get unlimited posts and we get unlimited video file sizes. And what that means is I can just upload the entire show up there. The reason why I don't upload the show to many other places is because it's a long show. I mean, we've been going for 2 hours now, sometimes 2.5 hours. It's a big video file and a lot of them have limits. I think on Gab, the Gab TV limit is, I think, 1 gigabyte, which is like nothing for us. And some of the other ones have limitations. So locals, as long as we get over that 1,000 member number, then it is, I think, unlimited. So I can just upload the whole show up there and sort of create a second home base. But I think we're like halfway there. So we got some work to do to get up there. My book, it's called Beginning to Winning, How to Fight Your Case and Succeed in the Criminal Justice System. I can explain it with a chart very quickly. So this is a chart that I call a strategy sheet. And in the strategy sheet, you'll see that there are these 9 boxes, 9 different phases. These are the phases that I think are most pertinent in a criminal case. And so the top one is sort of a brainstorming box. And then the bottom one is where I have all the different chapters. So you can see right there, the chapters are, establishing trust. How do you find a lawyer and trust them? Find a team. Goals. What are your goals? It's important we talk about goals. Otherwise, we can't get there. If we don't know where we're going, we don't know how to get there. Mitigation, that's how we separate you out from everybody else. If there's 100 people who've been charged with crimes, how do we make you stand out? There's a system for that. Discovery, we talk a lot about discovery. Interviews, how to interview police officers. Pleadings, what documents to file, what types of motions to submit in court. Negotiations, how you would communicate with a prosecutor or a judge. Settlement conferences, those things. Advocacy, the different stages of a case. So pretrial conferences, case management conferences, settlement conferences, evidentiary hearings, and so on. And then the results, how do you get results? What happens if you don't get the results that you want? And it's sort of a crash course on criminal law. There is an introduction in here to all of this where I talk a little bit about myself. I talk a little bit about my issues with alcohol, the loss of my brother a little bit. So a little bit of personal stuff. If you want to check that out, it is available on Amazon if you want to buy it, or it's available for free over on Locals if you want to check that one out as well. Thanks for asking about it there, Toots. We got Aaron Seavey says, Rob, is Discovery Brady different for state versus Fed? Arizona claims their disclosure is more than what's required. Shouldn't there be an equal for all standard? Yeah, I think that there should be more standards. Arizona's standard for Brady is just awful. It's just awful. And there's no rhyme or reason for it. If you want to take a disgusting look at how Arizona has Brady problems, go look. We covered it on the show, I think, a little bit, but I would watch the whole thing. There's a reporter here from ABC 15. His name is Dave Biscobing. Outstanding. He did like this 6-part, 45-minute special on just how terrible our Brady system is in Arizona. And I agree with you, Aaron. There should be higher standards across the board. What ends up happening, I think, is officers will move states. States don't really communicate with one another. So somebody will get in trouble in Arizona, move over to New Mexico, move over to Texas, wait a certain period of time. In Arizona, for a long period of time, they were just wiping officers' records clean after like 5 years. It was part of their union contract. The union would go to the city council and say, hey, unless you want our officers, you got to agree to our terms. The city says, well, we need officers. So they would have to agree to the terms of the union. And one of those terms was after 5 years, all those personnel problems just go right in the shredder. Nobody ever hears of them again. So as long as you can get past that 5-year mark, you're in the clear. What does that do for us as criminal defense attorneys? It's not good because we can't go look and investigate all of this malfeasance from these various officers. So it's a good question, huge problem. One of the things that I was proposing back when we were talking about solutions to the civil unrest in the summer as one of my solutions, hey, maybe we can talk about reforming Brady, reforming disclosure, because I think that would be very helpful in improving our justice system. Seiji Takahara says, I feel bad for Americans. If they will not do the same for the left, then those Capitol rioters should be set free. Just wrong. The legal system. A lot of problems with our legal system, Seiji. It's not just left versus right. I would say it's sort of the people versus the system. The system does everything it can to protect itself, and that's often at the expense of the people. We have Sally Sucka says, it's nice that you give free legal advice. Well, I'm not really giving any legal advice on this show. I'm talking about legal concepts, but we're not engaging in a attorney-client relationship. This is a live stream. A lot of people watch it, and I don't think that any person who's being reasonable could say that I'm acting as their attorney. But I am sort of, I have some ethical rules I gotta be careful with here. But we're talking about legal issues. If you are going to be acting on anything that I say, I would advise you not to do that unless you have already spoken with your personal lawyer about it and they are telling you to do it, because obviously I don't know you, right? We haven't sat down and had a real thorough conversation. We have another one from Chairman of the Board. We got Breonna shooting is, quote, racism, but the same thing happened to a white man, Duncan Lemp. No knock warrant, no body cam footage. No one even heard about it. Hard to find the right solutions to the wrong problems. Yeah, and Chairman, I largely agree with you. I mean, I think that there is clearly racism here in this country. There's clearly racial inequality. There are a lot of race problems around, and I don't think that that is something that we can scoff at. I do see it a lot. I see that there are sort of inequities between how the police will handle certain situations versus other. I see it on a regular basis. But my first instinct on this is not to just jump in and say, it's racist, right? Every single cop is a racist person. You can take a look at Breonna Taylor's case. Daniel Cameron, the attorney general who was responsible for the underlying investigation, is a black man. Okay, so to say like this is some sort of systemic racism, why is a black guy doing what he did to that grand jury at the expense of a black victim? How is that white supremacy or white race? I don't know. I don't understand it. Maybe it's just my white privilege talking. I have no idea. What I think the bigger problem is cops versus everybody else. It's law enforcement versus the rest of society. It's this big blue shield. They all circle the wagons. They protect themselves against any threats. And that's why Daniel Cameron was responsible for that. That's why he was participating in the manner that he was, because it's not about black versus white in this case. I'm sure there are elements of all of it. But I think the overriding, the superseding factor here is that Daniel Cameron is law enforcement protecting law enforcement. And there's just an institutional structure here where they all have the blue shield, the blue code of silence. Everybody protects one another. And that's at the expense of everybody else. Doesn't matter what your race is. I've seen white people get the shaft, Hispanic people get the shaft, Asian people, every version of a human being has gotten the shaft from law enforcement unnecessarily, unlawfully, unethically, many, 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 many times. The ones that you hear about are the ones that serve a political function, that move a narrative further. And it's wrong. I'm sure that there's race that's involved with it, but the bigger issue in my mind is law enforcement and the militaristic attitudes and the culture that they have developed in their individual departments over decades and decades and centuries, really. That is where I think the focus should be, because it's just bad across the board. Black, white, Asian, Hispanic, doesn't matter what it is. It's not good. We have another one from Sally Sucka. Says, if they pass a reparations tax on marking exempt. I think you'll probably find a lot of people want to join you in that. We got Hugo Munoz says, Thomas Sowell, discrimination and disparities. An economist in Harvard and U Chicago grad breaks down equity versus equality with research. Thomas Sowell is brilliant. So I would encourage you to go check that out. I have not read that one yet, but I will take a look at that. Thomas Sowell's pretty brilliant. He can synthesize very complex ideas, stuff that you would sort of be spinning in your head about for weeks. He can just put it into a paragraph or sometimes even a sentence, and you go, oh, got it. Check him out. Sammy Elliott says, you are smart and have charisma. Arizona GOP, LOL. I don't think so. Not even remotely close. I have no interest in getting involved with the Arizona GOP at all. We have Seiji Takahara says, big truth is a big lie. Big truth. Yeah. So he's capitalizing the B and the T and then he's lowercasing the B and the L on the big lie. So big truth is a big lie. Thanks, Seiji. Another one from Aaron Robb. If we continue stupid phrasing, I would like to start one. Stop the Women's Suffrage Act. I'm sure there won't be a lot of support for it. LOL, just kidding. Wasn't that on, did I see that on Ollie G? Did Ollie G do that, or Borat, or somebody? Might have been Ollie G. It might have been like a Jimmy Kimmel or something like that. Yeah, you go around and you go up to women like a man on the street type of thing. Listen, I'm here to stop women's suffrage. We have a lot of women who just are experiencing suffrage these days. And in order to fix this country, we have to eliminate all of women's suffrage. Don't you understand that? And they go, oh, yes, I know. My mother, she experienced suffrage when I was a child, and I'll never forget it. So yeah, I'm happy to sign the petition. Ban women's suffrage all day long. Good to see you, Aaron. We have Seiji Takahara. The split from Powell and Trump was not, quote, we knew it was absolutely false. The split was due to Powell being long-term and Rudy being short-term. I'm not sure what the falling out was there, but probably a good move. Sidney and the Linwood stuff. Some of their arguments I thought had water to them, or they had some merit to it. Not all of them. I was very critical of some of Sidney Powell's stuff just because I don't know why she kept pressing the Venezuela stuff, but it's her prerogative. But that doesn't mean that they didn't have some good arguments in there. But I just think it just got a little bit too off the rails for Trump, and they had to disavow. We have TZ 1052 New York says the Dems are crazy. Choosing a partisan senator to preside over the impeachment, I guess the Chief Justice turned them down, therefore illegitimate. Yeah, you make a very good point there. I think the Chief Justice, by him not being involved, that is really going to undermine the credibility of the entire thing. I think you'll see a lot of senators who are Republican senators use that as their excuse. It's called a fake because. They need to find a justification for the reason they vote. It could be because of anything, but they need to find one, whether it's real or not. In this case, you may have some senators who say, I don't know what to do on this thing. Okay, if I'm personally disgusted by what Trump did, or I personally don't care what Trump did, or I think this is all a sham, but they've got some other things to think about. Are they going to get primaried at the next election? Remember, a lot of senators are up in 2022. A lot of them. If they vote to impeach Donald Trump, are they going to get primaried by, pro-Trumpers in their home constituencies or not? And if they vote to impeach, they're going to get primaried. If they don't vote to impeach, maybe they lose the next general. Who knows? But I do agree that because John Roberts is not going to be involved, you might find some senators who just say, yeah, see, the whole thing's a sham, and I'm going to vote against it because of that. Chairman of the board, Rudy Powell, isn't a defense of defamation that you were saying something true? So if so, doesn't that open up all of their claims to discovery? So yeah, it's a complicated question there, Chairman. Sort of answered some of this previously, but it is. So I think people get a little bit confused about what this actually means. So, a defamation lawsuit is saying you did something bad and defamed us. Rudy can say, no, I didn't. It was a reasonable belief. I didn't intend to, actually cause actual malice, which is the standard, meaning I didn't intend to harm your business. I didn't intend to cause you all of this damage or destruction. That's not my point. I was talking about an opinion. I was talking about legitimate public issues. You're a public company, and I have the right to say this stuff. It's free speech. It's political speech. It's all highly protected, and therefore, I don't meet the standard of defamation of a public figure or a public company, and you can't sue me, right? And that's the argument. We can sue you. No, you can't. That's it. So the idea here that Rudy Giuliani can just sort of say, all right, well, I know you're suing me, but I'm going to need to investigate your whole company so I can come up with my defense to my defamation. That's not how that works. Okay. Dominion is still very, very much, I would say, protected in many ways, and they can still file a lawsuit. Rudy Giuliani now has to respond and come up with some sort of justification as to why he needs more additional material. But his first priority is to defend the allegation. The first priority is not to go in and start to investigate whatever he wants to investigate in Dominion's server room. So we're sort of talking about two different things. Now, if this litigation, heats up and goes in, and we have a number of discovery battles and back and forth, and they're talking about specific claims of fraud and specific allegations, then yeah, maybe discovery is narrowly tailored to answer and provide insight on that one issue. But it's not a free range. Some people think that you can just go in and say, okay, cool, Dominion sued, the counter response, and largely what Rudy and Sydney have been saying is like, hey, great, we're getting sued. Now we can go open up everything. I just don't think that is realistic. A judge is not going to allow that to happen. It's all going to be narrowly tailored to specific questions, and it's not going to be a free-for-all because the court doesn't want that to happen. Remember, the court is the arbiter between these two parties, and a court is not going to just say, oh, okay, there you go, Rudy. Whatever you want, Dominion, give it to them, and Dominion, whatever you want from Rudy, get it from him. Have at it, boys. That's just not how it works. It's going to be very, very narrowly tailored, and it's probably going to be something that is settled or dismissed without any real consequences, would be my guess. We have Seiji Takahari says, Leahy is impartial on procedure, but partial to procedure. If Chief Justice Roberts is not the presider, then the impeachment trial is a sham. And I think that is exactly what Rand Paul was saying. So you're in good company on that one. Test One says, how can Pelosi, Biden, Schumer, and so on keep getting away with this? And everyone else is getting sued. They are the criminals. That reminds me of that scene from Breaking Bad where Jesse Pinkman is saying, how can he keep getting away with this? So I think you are also in good company there, Test One. A lot of people feel that way, but I just think it's just standard politics, if I'm being honest. We have Paul O'Brien says, have you seen the WEF Great Reset stuff? I have seen a little bit about it, but I haven't studied it much, to be honest. I think the Great Reset is a slogan, is it? Or is it something serious and sinister? I don't know. I saw that Robert Barnes posted a tweet about it, but I didn't click through the link. I think he linked directly to their website, but I didn't click over yet. He's also on Locals, so if you want to head on over there, you can subscribe to him as well. I'll look into it. We have Sally Sucka says, I know you don't give advice. It was a joke, LOL. Sorry about that. Sorry, Sally. I went over my head. I just got to be extra careful about the legal advice stuff. We have Seiji Takahara again says, Snowflake guy is not wrong. Homicide is the killing of another person, right? Quote, my body, my choice works with suicide, but abortion involves killing. Seiji, That's pretty volatile, my friend. I like it. We have Sally Sucka says, don't forget, Tony Timpa, a white man killed the same way as George Floyd in 16. No riots, no worldwide extremism. Yeah, because some are useful, some are not. But in both cases, George Floyd, Breonna Taylor, Ahmaud Arbery, it's cops, okay? Cops against the people. And sometimes the cops happen to be black and the people happen to be black. Sometimes they happen to be white and the person who was killed happens to be black. Happens in a number of different permutations all around the world in all different shapes and sizes. And it's all wrong. And I'm not happy about it. We have Turd Ferguson says, I gladly accept the position with the impeachment party. There we have it, folks. We are in the beginning stages of the foundation of a new party. Woo, it's going to be wild. I'm excited for you there, Turd. We got another one. And it looks like, well, what's going on over here? Looks like we're about wrapping up. Let's see. Yep, I think this is the last one. All right, we have one from Ted Wendelbo. Says, if Giuliani already has his evidence that never got its day in court, can he blow Dominion and the election out of the water with it? So, if at this point in time, Rudy has any evidence that has not already been revealed in some way, shape, or form, then I think that is legal malpractice. That would be my opinion on that because it's too little too late. So I'm going to guess that he doesn't have anything that's a big catastrophic reveal. I would guess that it's probably just the same types of claims and evidence that he was already submitting and talking about, some of which is good, some of which I think is not so good. And he can respond in kind. The Dominion filed a 107-page lawsuit against him. So he can file another 100+ page response and he can respond to every one of their paragraphs and say, nope, here's the evidence we have for that. Here's the evidence we have for that, and so on and so forth. And believe me, we will cover that when he issues a response. I don't think Sidney Powell has drafted a response yet. I could have missed that one. I don't know. But my guess is that Rudy he doesn't have anything that's going to be a nuclear, explosion as it relates to Dominion. I'm going to guess that we heard most of their claims, but yes, he can respond to them and he can make the same allegations. They can say, hey, we didn't like what you said on this episode of whatever. And he can say, okay, well, here's why I said it. And this is true. And we've got documents to show this. And he can refer to his affidavits and he can refer to all of the other evidence that he's gathered. And so they can sort of have a pseudo election fight in their defamation suit. So it's going to be fun. And we hope that you join us for that there, Ted. All right. Our last one from Seiji Takahara says, please cancel me. I want to be canceled too. So Seji's just getting in. Join the impeachment party, Seji. We want you in the impeachment party. We don't want you in the canceled party. We got canceled. Okay. I was not happy about it last week. Not happy at all about it, but it's just part of the deal. It's part of the deal. We're playing the game and that type of stuff happens. And it looks like, my friends, that is it for us today. So let me wrap up with a couple quick thoughts. First and foremost, want to thank you for being a part of the program. We're back on Monday. We've got a full week ahead of us. I'm grateful that you're here. Would love it if you subscribe to the channel because we go live at this time every day of the week, and we want you to be here and join us for the conversation. I'd appreciate a like, thumbs up, share to somebody else who you think might enjoy the program. That's always very much appreciated. I want to say thank you to everybody who has joined us over on Locals. This is where everything is going to be. So we have Pinky 2, we got Ditka's Bears, we got Ronnie D, Corpan, Ham-Handed, Loxton, Sir Michael, Stank, we got Quayne, Bacon Seeds, Chris Wiseman, Sliding Edge, Fishcat, Takahari, Seji's on there. We got SMNK Joe 78, Farmer's Daughter 4, all of our newest supporters over on locals.com. You can join up over at watchingthewatchers.locals.com. It's free unless you want to comment. So we're learning more about the platform. If you want to comment or share, then you gotta chalk up $5. I think it's $5 a month. If you want to be a member over there, I will add your name to our board if you want it on there. The default is going to be if you sign up and join, you're going on the board. If you don't want to be on the board, let me know. If you want to modify your name a little bit, send me a message. As soon as you sign up, you can send me a message, send that over to me, and I will update your name on our board. And I want to fill this puppy up with love and support from you because the show is supported by you. I mean, that's where this all comes from. So I want to thank you for that. There's a lot over there. It's not just the name on a board. You've also got the slides from the show are going to be over there. You also have the book, Beginning to Winning. There's a free PDF in there. So you can get this copy. You don't even have to pay for it. It's $16.99 on Amazon. It's free over on Locals. So check that out. The existing systems that I've talked about, it's over there. My personal productivity system. All of the impeachment templates are over on Locals. We've got links. I posted some stuff over the weekend. I'm going to kind of intend to do that, kind of keep it, throwing some ideas out there and exploring some other things that maybe don't deserve a full video. So check that out. And then, of course, all of the other amazing people are over there. You've got Ma, you've got Faith, you've got all of the other people I just named who are all over there engaging in very helpful, useful conversation. And we want you to be a part of that. So that's it, my friends. One final thought is I am a criminal defense lawyer here in Arizona, in Scottsdale, and we are very good at helping good people who have been charged with crimes find safety, clarity, and hope in their cases and in their lives. And so if you know anybody who's in that position, it's unfortunate, but there is a lot that we can do to help. We would very much appreciate a referral. We'd be humbled and honored if you trusted us enough to send them our direction, because we're very good at what we do. We are the best, in my opinion. I mean, come on, the best. We're very good at what we do. We're very compassionate with people. They're going to leave our office in a better position than in which they came. And it would just mean the world to us if you sent them our direction. So that's all that I have. Let's leave it at that. We'll be back here tomorrow, same place, same time, 5 p.m. Arizona, which is Mountain, 4 p.m. in California on the West Coast. We've got 6 p.m. in Texas in Central Time, and then 7 p.m. on the East Coast. I want to thank you once again for being a part of the program. I look forward to seeing you here tomorrow and the remainder of the week. Everybody have a wonderful evening. Sleep well. See you tomorrow. Bye-bye.